the fact that Bundy is binding, I think the rule in Bundy makes good sense for a couple of reasons. If a defendant is preserving an appeal on a particular issue and then succeeds at the Court of Appeals, the remedy in Rule 11 is just vacatur of the plea, and it's sort of set back to the pre-plea state of affairs, and whichever rulings control on motions to suppress or constitutional rights are then bound. But then the government has to make an independent determination of whether to continue to try the individual given those holdings or not. And as Bundy, I think, very clearly articulated, if that is sort of a non-essential issue, if the government doesn't need a particular piece of evidence, doesn't care about it particularly strongly, it's just going to go to trial anyway, and there will have been an entire series of plea proceedings and appeals that happened when they were just unnecessary. As to your question about the text,
help me understand. I'm just trying to understand why the government it supports this rule at all, because it means that you're both you, and I don't mean you personally, obviously, but your office is no longer able to reach agreements on issues that are not case dispositive, right? Or allow appeal of non-case dispositive issues. But we know that non-case dispositive issues can still be really important to the decision on whether to go to trial or not, right? So maybe not in this case so much, but we can certainly imagine a case where there's physical evidence sufficient to try someone, but the confession is really the nail in the coffin. And so whether the confession comes in or not would be a really important piece of information for the defendant in particular, but for the government as well, to know whether it's going to come in or not come in, to evaluate those choices. But it might not be a tool of permitting a defendant to plead guilty and preserve a really important piece of evidence, but maybe not a case dispositive. Why is that a rule that the government thinks is a good idea?
I think the same considerations for the government apply to what the court decided in Bundy. The government, when taking a plea, right, part of what they're bargaining for is not having to go to trial, saving
that in your own discretion, right? So what I'm trying to figure out is, why is there a judicial rule? Why do you favor a judicial rule? Because all you have to do is say, nope, not going to agree, right? Unreviewable discretion, right? It's only when your trial counsel, your line AUSA, wanted to agree, right? Or maybe there wasn't a meeting of minds here, but judicial, why is the government in favor? And you began by saying this is a good rule. I get your point. It's a binding rule. I agree with that. But I don't understand your argument that it's a good one.
I think it's because the way Rule 11 is phrased, with both the court and the government having to consent, is designed to provide independent case dispositive. The Bundy rule ensures that the resources of both the government and the court are saved minimally possible. And I realize it's sort of ironic we're here at argument.
All right, so, but why would we give you the second bite of the apple, right? I mean, all right, so let's assume you're right, and this was just like a mess up, right? Which it happens, right? Lawyers make mistakes, so do defendants. But why is it that you're the one getting the second bite of the apple, as opposed to us relying on your executive discretion, the defendant's voluntary agreement, and the district court's own review?
I'm not sure I would agree that we are getting a second bite at the apple. This is not an opportunity for the government to go back and get a better plea bargain. The defendant might choose that he wishes to preserve these issues and make us go to trial and prove our case. The power about whether or not to preserve these issues for ultimate review by this court rests entirely with the defendant. He has the option to elect to go to trial and put the government to its burden of proof, or to decide those issues are not important to him and then take a plea. So I don't think this is a situation where we're getting a benefit out of the Bundy rule that is sort of unfair because we get a second bite at the apple.
So do you read Bundy to say, in this logical or illogical extent, that if you go back and the defendant says, well, you know what, I still want to plead guilty, but I want to preserve, that could never happen because it'd be a stone you could never pull up the hill, right? You'd be back where we are.
Yes, Your Honor. The defendant would have the option to either plead without the non-case dispositive issue being preserved, or if he wishes to preserve the issue, he could then make the government go to trial. And then the government would have to make a determination. Do we want to introduce that piece of evidence and have it be part of a harmlessness analysis on the back end? Or we might omit the evidence entirely because we don't want to buy the issue of it for issue.
But you still want to keep your district court ruling on the suppression motion, don't you?
Yes, Your Honor.
Hey, you want that.
Yes, Your Honor.
But you don't want us to be able to now determine whether or not that was legally correct.
Now, Your Honor?
Now, today. Well, at least 75 days or so from now.
As if the chief, might be longer if it's me.
No, Your Honor, and part of this is Bundy is binding on the government as well, and we felt we had a duty to bring it to the court's attention when we realized the issue was not case dispositive. This court is free to apply Bundy if it sees fit. It is the court's rule. But in this circumstance, we think that for the judicial economy and the prosecutorial economy of the situation, it's much better dealt with either a plea that is in fact final and binding, conditioned on a case dispositive issue, or going to trial where the government puts forth its evidence and tries its best case. Unless the court has further questions on Bundy, I'll move to the Terry stop. So one of the points that my friend on the other side suggested is that there's a difference between the Hodari D standard and the Mendenhall standard about free to leave seizures versus show of authority versus physical force. And I don't think that's borne out in the case law. The Mendenhall standard articulates two independent requirements for a seizure. There has to be an indication from the police that a detention is happening, or indication sufficient to tell the person, a reasonable person, that they are not free to leave. That requires both actions by the police that communicate that and a reasonable person on the other side thinking that they are not free to leave.
Well, we have that one here. You agree with that, right?
Once he trips and the officers get hands on him.
Once he trips, before he trips, really?
I disagree, Your Honor.
Have you seen the video? The officer says, and it's better seen not by the camera on the officer who asked for him to come, but the other officers can. He's halfway down the street and the fella's still standing there. Really, he's charging him. You don't think a reasonable person would say, wait a minute, the police officer's charging me like this. I'm certainly not free to leave because it's like you know what I'm saying? It's a rush on me. I mean, he wasn't walking and say, come here, and slowly walk. He, as people say on the street, he bum rushed him. Didn't he? I mean, you saw it. I know you counsel for the government, but you got to common sense in what you can see is he did. He didn't just.
I agree, Your Honor. It was a fast approach.
But what's the other problem we got to get in Mendenhall? What you said? There's one. But what's the second one?
So the second one is that they have to indicate to a reasonable person on the other side not to feel free to leave. And it is a totality of the circumstances analysis. But what Hodari D did, and cases applying Hodari D subsequently, is they said when there is no submission to the show of authority in the first place, a seizure has not occurred because the Fourth Amendment doesn't touch attempted seizures. It only touches actual seizures. And so unless the person submits to the show of authority in the first place, they haven't been seized within the meaning of the Fourth Amendment. And here, as my friend points out in her briefing, the defendant was trying to get away. He did not hands on him. The physical component of seizure had been met, and he had been therefore seized. I
just want to make sure I understand the argument. Your basic point, as I take it, is after Torres, the recent Supreme Court decision in Torres at least, but probably before that, if there's physical force applied, it matters not whether you submit, right? So if I grab you and you pull away, physical force has been applied, so your submission matters not. That's a seizure. In contrast, no matter how menacing or imposing my approach is, and no matter how reasonable your belief is, if you turn and run before I get to you, that's what Hodari D tells us. It matters not the show of authority or how it was understood because you did not actually submit to it.
Correct, Your Honor. And I think Stover is a perfect example of this. In Stover, the defendant was surrounded by uniformed officers, police cars with their weapons drawn, telling him to get on the ground, put his hands on his head, and the defendant kept moving around still holding a firearm. And this court held that because he was still moving around with the firearm and had not actually submitted to the show of authority yet, he had not yet been seized. And I struggle to think of a more intimidating.
The first part of this is what I'm trying to understand, because I couldn't tell from your argument a minute ago. Are you arguing that there was no show of authority here, that it wasn't reasonably understood to be a show of authority? or only that he didn't submit to it? It doesn't matter how strong the show was.
I think the show of authority question is closer than the submission question. I think there is not enough.
No offense.
None taken.
I have a couple of questions. I think the hardest question for me in this case is about the search of the bag, which I am not at all convinced was legitimate. So can I ask you a couple of questions about that?
Definitely.
So what was he arrested for? I'm struggling per the chief's question. I don't understand what he was arrested for.
He was arrested for being a felon in possession.
But you didn't know he was a felon in possession at that point. You didn't know he was a felon in possession until he confirmed his identity, which was after he was cuffed.
Yes, Your Honor. But see, the cuffing at the beginning was just within the scope of an investigative detention. It wasn't yet a formal custodial arrest. This court has held that. But you searched
the bag. Do you agree that he was, your briefing was a little confused about this. Do you think he was under arrest at the moment they searched the bag?
No, Your Honor, I do not.
Okay, so it's not a search incident to arrest.
It is not a search incident to arrest. I think I would argue that the search of the bag or the Officer Tyree Williams feeling the gun in the bag was not even a frisk. At that point, she was removing the bag, which was presenting a choking hazard. I don't think her intent was to search the bag.
No, but opening the bag is clearly searching the bag.
Yes, but at that point, Your Honor, she had already felt the hard object inside that she testified felt like a gun to her.
Whoa, so I did not. Do you have a cite in the record for the proposition she said it, quote, felt like a gun to her? Because that seems very different than what I understood her to have testified to. While you look, I read her as saying it was hard, and to me that suggested there might be a gun in there. That is different than saying it felt like a gun. Right?
Yes, Your Honor. I think that's correct. I apologize. I think I overstated that.
Is that under there's one sort of line of avenue here, like, is there reasonable suspicion he was armed and dangerous? There's a second line of avenue I think is distinct, which is sort of what I think of as the plain feel exception. That might not be right phrasing, but that's the way I think of it. Do you think the information she provided suffices under the plain feel exception? Do you have to say, I knew it was a gun, or what information does the officer have to have in order to use the plain feel exception to conduct a search?
So separating the plain feel standard from the Terry stop standard and the standard for a frisk, excuse me. The plain feel standard requires essentially probable cause to believe that it's contraband or a weapon that is dangerous in some fashion. I think at that point where there had been a report of a firing of a gun, the individual is attempting to reach for the bag as he's being restrained by the police. She cuts it off him and then feels a hard object inside that she said suggests to her a weapon. I think at that point you have enough under the plain field doctrine.
So you're in essence taking all of those together. The plain field doctrine to you is you take all the Terry information and then you say there's a hard object in the bag. And the question then is, do you have probable cause that it's a gun, as opposed to, do you have reasonable suspicion he's armed and dangerous before she touches the hard object?
Correct.
That's the intellectual framework.
Correct, Your Honor. And I think the government would argue that we win under either standard. Can
you point me anywhere where you've argued the plain field exception to either the district court or this court? I see you as exclusively arguing this is a Terry frisk, and that's concerning to me because I'm not sure that you have reasonable suspicion that he's armed and dangerous.
I don't believe we have articulated the plain field argument.
Then you can't argue, can you?
Your Honor, this court has the ability to affirm on any basis that appears in the record. Can
I ask this question a slightly different way? Right. The question, you've articulated the plain field exception as being requiring probable cause to do. The question of whether a frisk can be done is based on the information known at the time. Your position is there was no frisk done until after the bag was removed. And so feeling a hard object is part of the totality of the circumstances that was known to the officer at the time they completed the frisk, which was opening the bag.
Correct, Your Honor. I think at this point, when the purpose of removing the bag was not to frisk it, to check it for weapons, or even to search it, the feeling the hard object in there is one factor that adds to the reasonable suspicion that the defendant was armed and dangerous.
Can I go back to the question of whether this was the same guy? Because as I told your colleague, I think there's clearly probable cause to believe the man in the apartment committed a crime. So the question is this the man? So on page 5, in footnote 5 of your red brief, you quote JA 43 as saying that Officer Wilson testified that they were the same man. I guess I will say that I've read that and I don't read it the same way. I read him saying is it turns out it was the same man, which seems to me to be assuming the answer to the question. Do you have anything else in the record that supports your claim that it was the same man, that the man outside the apartment was the same as the man that they arrested on Fairfield Avenue, other than that statement from footnote 5 of your red brief?
I believe it's on page 53, Your Honor, where Officer Wilson is recounting seeing the individual walk toward him on Fairfield Avenue. I think he testified that the individual matched the description, saw him in the identical attire as the man he had seen change his shirt from the black shirt to the white tank top, and that he had the same body structure, and that he concluded that it was the same person. And I think because the district court accepted that and made a credibility determination that it was the same individual, I think the defendant would have to show clear error to have that factual finding overturned.
Where does the district court say that?
I believe it is on page 232 or 234. In the district court, it is at least, speaking generally, is at least in the district court's recitation of the facts, which the district court noted was drawn from the evidentiary hearing.
This case really is, you look at it, it's, the question is, it seems like you're identifying the person that the officer saw in the vicinity, and that person being the person, not necessarily the person who was described, because a lot of questions like, was it all black? No, it was black. Or did it have sparkles on it? No, it was all black. Trying to almost get it to fit the person they saw outside. And then you follow the person on the outside. Is it really a connection there? Because even with the gun, the lady said, no, well, gunfire all the time. I'm not sure it was a gunfire at all. It did strike her in the face. So where's the reasonable suspicion that he had that person outside had a gun? Because really that's what he's identifying. He's following the person I saw outside.
Yes, Your Honor.
He's not following a real description from the person who's the victim, because that person was saying, I don't know his name. He wasn't wearing what that person is, what you're talking about. Gunfire, no, I don't think it was gunfire. I hear it all the time. It didn't happen here. But you're making it fit in the round peg and the square hole, because no, I'm convinced that the person I saw out here, and that's who was followed, but being the person outside, isn't it?
So I think it's important to distinguish between what the victim told the police officers and what the woman who called 911, the complainant, told the officer. So the victim, Officer Tyree Williams tested, was very uncooperative, refused to name her long-term boyfriend, said she didn't remember, and so was not really forthcoming. And so I think police officers aren't required to accept that as being reliable when a witness is being uncooperative. The other thing I would point out is that courts have held that the description of the suspect need not be exact because of the reasonable suspicion standard. So a black shirt and dark pants that are generally the same as an all black versus a black shirt with colors is sufficient to support reasonable suspicion, especially in light of the defendant's flight from police officers in the immediate temporal and physical proximity to where the crime was reported. So I don't think that factor alone, the distinction between an all black shirt and a black shirt with sparkles, is enough to defeat reasonable suspicion, particularly in light of the other circumstances.
So any black man in the area with wearing black, they could do the same thing to that they did here, couldn't they?
Your Honor, I think they would need more than just, they would need the temporal and physical proximity. They would need flight from police officers. I don't think just... No, the flight from the police officer, no, the police officer ran after him. We talked about that. Not the first two times, Your Honor. The first two times the man took off running away from police officers without... He walked away the first time, didn't he? No, Your Honor. He walked away, he ran away. He ran away because Officer Wilson testified that he instructed the second patrol car to make a U-turn and stop and talk to that man. And as soon as he saw the car make the U-turn, he took off running. Officer Wilson testified. And then the second time. Okay. The second time, when Officer Wilson yelled at the other police officers to try to get their attention, the man heard him and then again took off running after having changed his clothes. Again, another indication of furtive behavior. He changed his clothes. He took his shirt off. Yes, Your Honor. He took his shirt off. He put a bag down and then took off running when.
But he had on a beater, right?
Yes, Your Honor.
But that's common to have a beater as the outside shirt, isn't it?
The clothing itself, Your Honor, is not suspicious, but again, even innocent facts when put together support reasonable suspicion. And again, I have to point out that the Supreme Court has repeatedly held that flight from police officers is a strong indication of mens rea. So it's not just that a man changed his shirt on the street, it's that he took off running from police officers, went around the corner of a building, changed out of one shirt into another, took off running again when he saw police officers, and then took off running the third time. He was in close temporal and physical proximity to where the crime was reported.
But that allows you to make a Terry stop.
Yes, Your Honor.
Only.
Correct, Your Honor. I don't think they had probable cause to arrest at that time.
Can I ask one, Chief? I apologize.
Yeah, sure.
One follow-up. I just want to make sure that I understand the full scope of the evidence when I go back to look at it. I understand the district court finding, which is at JA 233, that you referenced.
Right in between.
And then I understand, yeah, that's not a correction. I just want to make sure I'm not missing something, right? JA 53 is Wilson's testimony that the district court is referring to there. If I'm looking for citations for the following fact, the man that ran the first two times, there was reason to believe was the same man that was on Fairfield Avenue. Is there anything else that I look at other than Officer Wilson's testimony and the district court's crediting of that testimony in its opinion? Am I missing any other piece of evidence?
I would say that it's corroborated, Your Honor, because the reason Officer Wilson went to Fairfield Avenue in the first place was because his sergeant told him a man who matched the description that he gave was walking down Fairfield Avenue. So to the extent you need it, there's a second officer saying, hey, that individual matches the description that you gave me of the person you saw running. So it's not just Officer Wilson, but I think Officer Wilson's personal observations are probably.
Is there any geographic information? So I'm obviously not that familiar with where Fairfield Avenue is in relation, but was it in the direction he was running, or do we have any of that? I'm not asking for anything outside the record, obviously, to be very clear.
Yes,
do you have any information about that was the direction he was traveling when he was last seen, or any of that?
Yes, Your Honor, I think so. I don't have the citation in front of me, but there's a portion in the evidentiary hearing where both the prosecution and the defense put up maps of Creighton Court and Fairfield Avenue and had the officers indicate all the locations that these happened. So
are those in the JA?
I don't believe the maps, I don't believe are in the JA. The discussion surrounding them is, and I can't say that there is a specific, I don't know whether there is a specific statement that it was in the direction that the man was running. If it existed, it would be in that discussion.
Thank you. Sorry, Chief.
Oh, no problem. Ms. Platt, you have some time to preserve.
Thank you, Your Honors. To pick up on the sort of identity and description point that you all were just discussing, I think I would like to note that there are several mismatches between, and I think as the court in its entirety was just picking up. There's the description from, my friend was noting that there's the girlfriend whose name is Miss Anderson, and the 911 caller, the friend, Miss Holman. And even if the police officers want to discount the girlfriend who doesn't want to cooperate against her boyfriend, there's a temporal problem at the start between the man that Officer Wilson and Officer Tyree Williams saw outside the apartment and the man inside the apartment who there is probable cause to believe committed some version of simple assault. Because Miss Holman, the friend, not the girlfriend who doesn't want to cooperate, but the 911 caller friend, Miss Holman, immediately told the police, he's long gone. So right when the police saw whoever this guy was outside in Creighton Court, the friend, the 911 caller said, oh no, but the boyfriend's long gone. So at that point, there's already a temporal problem suggesting that whoever Wilson targeted outside might not have been the boyfriend in the first place, because the boyfriend was long gone, and not according to the non-cooperative girlfriend, but according to the 911 caller, Miss Holman. And that's on the video that this court can consider directly.
Yeah, I thought that was interesting too, that it's already happened. It took the time to respond. So he's gonna wait until the police cars get there visibly, and then I'll start running when they get here.
So this temporal problem exists from the beginning, that whoever Wilson was chasing may not have been the boyfriend. So secondarily, as the court was noting, there's this problem of the clothing. There's speckled pants, there's blue jeans, there's an all black shirt, there's a colored shirt. These descriptions didn't match. And Officer Wilson noted, it's in the video and it's in the district court opinion, that's the wrong description. Officer Wilson noted that there was a description problem the whole way through of whoever this person was that he was chasing through Creighton Court, and the description of the boyfriend, and again, not just from Miss Anderson, but also Miss Holman, the friend, the 911 caller, said it was an all black t-shirt. This is not just to be discounted because the girlfriend doesn't want her boyfriend, to get caught up.
So can I ask you about a way to potentially reconcile this that occurred to the people in my office? So let's say there's 4 people. So person 1 is the man in the apartment who commits the simple assault. Person 2 is the man that the officers see outside as they arrive. Person 3 is the man who removes the black shirt. Person 4 is the person they arrest. Do all of these problems vanish if you just drop the assumption that person number 2 is the same as the others? In other words, if you assume that so I understand the discrepancy being that the man they see outside has colors on his shirt, and that doesn't match. I agree with you. That doesn't match the complaining witnesses. But the man they see removing the shirt is wearing an all black shirt, which matches the complaining witness's description.
Or even it wouldn't matter what color that shirt was because he removes it and there's a white.
But they see him remove a black shirt, which matches the description of the complaining witness. That also seems to solve the temporal thing you identify. I guess my question is, if you imagine that person just drops out entirely, what I'm calling person 2, is there any mismatch at all?
I think there's, I don't know if I would call it a mismatch, Your Honor, but I think at that point you're getting to an attenuation problem because it's further in time. And at this point, it's not that late at night. You're in Creighton Court. It's a densely populated, place in Richmond with lots of people around. At that point, again, you're getting to a Bruegel problem where you have not eliminated a sufficient portion of innocent travelers. That could be any man in Creighton Court just removing a shirt.
Wait, you just said something, which I think opens up the question. How do I know there's a lot of people around? This is a Thursday night at about 11. And when I watch the video, I see very few people outside.
I only mean in terms of residents, right? We do know, and it's in prior precedent of this court. It's a densely populated housing area of Richmond where hundreds of families live in Creighton Court.
But you just asserted that there's lots of people out and about.
I meant by around, I meant just that live there. I did not mean out and about outside. I meant just that reside in location because it's a densely populated area of Richmond. And that is, while not in the record, it's in this court's case law. And so I also want to note in terms of the, let's leave it to the flight on Fairfield Avenue. This court in Black at page 538 wrote, quote, Black's subsequent decision to leave does not negate the finding that a reasonable person in Black's circumstances would not feel free to leave. This gets back to our Mendenhall free to leave test. Quote, instead, Black's decision to leave was an effort to terminate an illegal seizure. This gets back to the point I was trying to make earlier. If I could, again, call the court's attention to footnote 3 in Black, which is about Brendlin versus California. I really firmly believe that this resolves the Hodari D versus Mendenhall test issue in this case specifically, because Brendlin on page 255 says, quote, when the actions of the police do not show an unambiguous intent to restrain, that's the end of the quote. So as my colleague was saying, and as they said on page 14 of their brief, this is from the red brief, it is not at all clear that the officer's conduct even rose to the level of a show of authority under Mendenhall. That's a concession here, I think, that this case is governed by Brendlin, that the Hodari D, what they call an attempted seizure problem, is not a problem in this case. This is a Mendenhall free to leave case, which means, as the court was indicating, as soon as the police officers rolled up and started yelling at Mr. Buster, hey, we want to talk to you, and started walking at him very quickly, as Judge Gregory was noting, as Chief Judge Gregory was noting, this was a Mendenhall seizure at that point. And so the flight on Fairfield Avenue is not a factor that goes to reasonable suspicion in this case. And Brendlin and this court's decision in Black make that
wait, so just so I understand, you reject the notion, even after Torres, that a show of authority, even a show of authority that is not submitted to, you think that is a seizure?
I think, Your Honor, under Brendlin and under Torres, if the police show of authority is an unambiguous assertion, like stop in the name of the law or halt police, I think then you get to the Hodari D for Torres type thing, or a physical restraint type thing. But in this case, where it's an ambiguous Mendenhall seizure, but still a Mendenhall seizure because a reasonable person is not free to leave, then there are no Hodari D problems. I think that's what, again, page 255 of Brendlin makes this very
All
clear.
right, I think I understand your point.
So it has to be sufficiently unambiguous that then you get into Hodari attempted seizure paradigm. But if it's a Mendenhall free to leave seizure, but it's not sufficiently unambiguous, Brendlin resolves this again on page 255, and it's referenced in footnote 3 of this court's opinion in Black. Finally, Your Honors, let's see. Finally, on the Rule 11 point, my colleague made a good point, which is, all that happens if the court does not agree that Bundy and this case are reconcilable is that, we go back, you vacate Mr. Buster's legal guilty plea, and then, my colleague can either go to trial or do a trial on stipulated facts or whatever. I think, there's two problems specifically in this case that are both practical. The first one is, of course, in this case that we've now spent a year in this court. My client has been, detained that entire time and so forth. The other thing I would say is that, there's a trial penalty, and I understand that doesn't get into the, whether you are bound by Bundy or whatever, but, the 3 points that you get for going to trial is not under the guidelines insignificant. And so he says there's no harm whatsoever to the defendant for going to trial. That is harm.
At least many district court judges award acceptance of responsibility for a trial on stipulated facts.
Some, but not all. I guess it's an open thing. But I agree, it occasionally happens. So I think, Your Honors, if I see I've once again, I would note as Judge Hayton said that the plain field exception in this case has not ever been argued or referenced until Judge Richardson's query. So if the court has no further questions, we would ask this court to reverse the district court either on the seizure or on the frisk.
Thank you, Ms. Platt, and thank you, counsel. Appreciate your arguments. We can't come down and shake your hands under our circumstance, but please know that we very much appreciate your being here and helping us resolve these very thorny issues. And I wish you well and be safe.
Thank you, Your Honor.
Thank you. And we'll ask the clerk to announce a recess.
This honorable court will take a brief recess.
Okay, that's great. About me, I just wanted to make sure I knew.
Yes, indeed. Hopefully. See you, Caroline. Have a good trip back.
he has to plead an imminent danger of serious physical injury. And second, he must show a nexus or connection between his claims and the alleged imminent danger. After Mr. Hall satisfies both elements, his request to proceed without prepaying the filing fee should be granted. Now, the United States has already conceded that Mr. Hall met the second requirement, that his claims are connected to the imminent danger as set forth in the complaint. With the second step complete, Mr. Hall must only meet the imminent danger of serious physical injury standard. And we suggest that Mr. Hall's complaint does meet that standard. The most serious medical condition that identified by Mr. Hall is a COPD and the associated respiratory illnesses, including asthma. At Joint Appendix 11, Mr. Hall stated that he has chronic asthma, chronic COPD, depletion of lung capacity to 49% without medication.
I'm sorry, counsel. I just want to make sure that I heard you. You said the most serious were which two?
Sure. The most serious conditions in his complaint are the chronic COPD and associated respiratory issues along with that. I would group those all together and call those respiratory issues on behalf of Mr. Hall. But I would say I would use the COPD as the primary issue.
And you're including in that the nodule finding the mask in his lungs?
To be honest, Your Honor, not being a doctor, I don't know if that would necessarily impact his respiratory ability to breathe, but
I think you said the key not being a doctor.
Right.
Isn't that the whole point? You argue the case where you want, but isn't that the whole thing, that he wants intervention of a medical skilled person? I mean, the mask is growing, isn't it?
Yes, Your Honor, that is.
I mean, somebody tell you it's 6 millimeters, then now it's 8, and you already have a reduction in air capacity. I mean, it's interesting. You think that's, but anyway, like I say, you argue the case the way you want, but notice you didn't mention
No, fair point, Your Honor. I do believe that would be included within respiratory issues and his ability to breathe, and I would kind of encompass all those things together.
Well, that's what I just want to make sure. Okay, go ahead.
Can you? I understand you're not a doctor, but nor am I. And so tell me what we do with the idea that he had in 2019 they found a nodule in his lungs, specifically referring to that, and then in 2020, about a month before he files the complaint, they do a follow-up, and according to the documents your client submitted, they found the nodule to be stable. And so the complaint that wasn't being followed up on and that it wasn't stable seems hard for me to get my head around. So why shouldn't I read those as saying the 2019 identification of the nodule was followed up in April 1st or whatever it was of 2020? He filed suit on May 7th of 2020. And so whatever we want to say, the follow-up on the nodule was done and indicated that it was stable. And so it's hard to say that's an imminent danger. Why isn't that the right way to think about the nodule?
That's fair with respect to the nodule, Your Honor. I mean, it's hard for me to say that the nodule, that he was getting the requisite treatment for the nodule based on his allegations in the complaint without knowing the proper standard of care that he has to set forth. But I would kind of encompass, go back to all of the COPD issues and all of the breathing and respiratory issues would be encompassed together. And so if maybe perhaps the nodule was receiving treatment, however, he wasn't receiving treatment for the other issues associated with the COPD, or at least as set forth in his complaint.
Counsel, I have a question. How does the recent Myers decision impact your analysis? In that case, this court actually went to a dictionary to define imminent as threatening to occur immediately, dangerously impending, or about to take place. How do the facts of your case line up with the Myers decision?
Sure, Your Honor. I think Myers, in addition to a number of other circuit court decisions that the United States actually cited in their brief, addressed this issue in that the delay and denial of medical care for certain issues can qualify as an imminent danger. Now, the cases cited include Ibrahim versus District of Columbia from the DC Circuit, Vanderveer versus Prison Health Services from the 6th Circuit, and Brown versus Johnson from the 11th Circuit. All of those cases involve prisoners bringing claims primarily under the 8th Amendment and seeking relief for failure to provide adequate medical care. All of those prisoners had hepatitis C and other associated issues for which they claimed that they were not receiving the proper treatment. And the courts all found that there was enough set forth in their complaints in order to get by the fee requirement in the Prison Litigation Reform Act, in order to say that those claims are an imminent danger of serious physical injury, because the delay and denial of medical care for those conditions can cause death. Now, we would suggest that COPD has the same outcome. It's just as serious. It actually kills 150,000 Americans per year.
All right, can you stop for a second? So you're now describing facts about COPD that I don't see in the complaint. I don't see in the record. And so I guess I want to sort of take a step back and sort of ask a couple questions. We have medical records now that were submitted in connection with the IFP request on appeal. Those medical records were not considered by the district court in the first instance, right?
Correct.
Tell me why we should, evaluate those medical records. I mean, I just talked to you about the nodule, right? But why we should evaluate those as a initial matter, and why instead we shouldn't address the nexus / traceability. And I want to talk about that. And if we figure out that you've met that requirement, or that such a requirement doesn't exist, that in fact the imminent danger of serious bodily injury is something that ought to be remanded for the district court to evaluate those records that we just got. Oh, so this is in no way a critique of you. I'm just trying to understand from a court's perspective why we're looking at medical records for the first time. Sure.
And so we approach if for its review. But I think you hit on the fair points with respect to redressability, is that if the decision on whether or not that is applicable here, and if the fairly traceable relationship is established, are also the two other issues that must be addressed before it can even get sent back.
So can you help me maybe this is more for your colleague, but I'm having a little trouble. Y'all seem to sort of agree that there's a nexus requirement, and you seem to disagree about what's required to meet that standard. For example, does it include traceability or not? But the premise of that question is that there is a nexus requirement. And I can't quite figure out why there's a nexus requirement. Can you help me understand why, based on the text of 1915G or the purpose or legislative history, anything you want to point to, frankly, where the nexus requirement comes from?
Sure. So there is nothing within the statute itself or the legislative history, I think, that discusses the nexus. The Myers case, as articulated by your colleague, that was the first case in the Fourth Circuit that brought up the nexus issue and addressed it in the context of the overall purpose of the Prison Litigation Reform Act to cut down on frivolous lawsuits. And I think as that point was argued pretty well within that case and in the opinion.
But Myers is an unpublished decision that doesn't bind it. I mean, it might be persuasive, right? I understand that. And so you're in essence saying that the rationale provided by Myers, whichever one it is the rationale that you see as reasonable for inferring or creating this nexus requirement.
Yeah, we do think that there should be some connection between the imminent danger of physical injury alleged by the prisoner and his claims presented. And so in Myers, we had Social Security Administration claims that were brought, and then the imminent danger was the threat from a drug lord that was totally unrelated to the Social Security claims. We're saying we do agree that there should be some connection between the imminent danger and the claims presented, so at least that there's a consistency across those two issues. So Mr. Hall also set forth in his joint appendix at 12, history of breathing problems, issues with the medication, severe asthma attack that required additional emergency treatment with steroids, antibiotics, and nebulizer treatments.
Hey, can I ask a follow-up question back to the imminent danger point? So the statute says that the prisoner, obviously the focus there on the prisoner, but the prisoner is under imminent danger. It doesn't say that the prisoner alleges that he's under imminent danger. Is the court required to make a factual determination that it is likely or plausible that the imminent danger exists? So, for example, if a prisoner claims that he is in imminent danger of being eaten by a Martian, the district court can reject that on its face. And I assume you agree with that, right?
Yes, Your Honor.
Okay. And so then the question is, what do we do in the scenario where he says, I'm in danger of a growing nodule in my lung, a cancerous nodule in my lung, and the medical records submitted by the plaintiff himself are inconsistent with that, right? The nodule is not in fact growing. And this is a hypothetical. I'm not trying to get into the facts of this case, but in fact, it is being evaluated and is stable. Is the district court in that instance required to reject the allegation of imminent danger because it's inconsistent with the unopposed facts?
I think as part of the notice pleading standard and what is submitted to the district court, it can take in a totality of what is presented by the plaintiff and by the prisoner. So if that is the result of how everything appears, that they're saying that is their imminent danger, that they have a nodule, that it's not being cared for, and they submit medical records showing that it is being cared for. I do think that is within the court's discretion to review that in its totality to make its decision.
Counsel, you would agree that in the context of a case such as this, all these circumstances, whether something is indeed an imminent danger, is driven by the facts of the particular case. So there can never be any bright line rule. Would you agree with that?
I would agree with that, Your Honor.
And if that is indeed the case, who would be in the best position to make the determination as to whether something is indeed an imminent danger or not?
I think it's up to the district court in their review of the record before them at the time the application is submitted.
Why do you think that, counsel? Why do you say that? Why is the district court in a better position to determine a field that, and this is no disrespect to the district court, this is generically, in a field that none of us, appellate or trial judges, have any qualifications for? Why would that be the case?
Well, I think you just hit one of the highlights of one of the issues with the analysis is that we have the district court reviewing medical records and allegations made by prisoner applicants regarding what could be serious medical conditions without necessarily fully understanding all of the medical issues that are, what they mean and what they're impacting.
The problem with these cases are the very person allegedly who has control over his life situation is also the person that has control of all the medical records. I mean, you would love to have in a civil case, you would get, your Rule 26 type of submissions and have your experts to show that a nodule of this type is anything but stable. Matter of fact, it could be an indication of being malignant. We don't know that. But the key is, I assume what you're arguing is that this is a situation where it is life-altering. Imminency in terms of medical thing, that's like saying, well, you have appendicitis right now, you're symptomatic for acute abdominal pain to the right side. And also we'll find by your white corpuscle count, that's indication of infection. But you're not going to die yet unless it bursts. So until it bursts, then you're not imminent. That can't be the case, is it?
No, Your Honor.
It has to be driven by science. It has to be driven by that. Not in terms of whether or not it's whether you're going to die. Maybe he may. See, here's the problem. He could live a life of 40 more years. But if you don't do something now, he may only live 1 year. So is that the definition? It's not imminent because you don't live a year. That would be absurd, wouldn't it?
Yes.
I don't understand your argument. You seem to be capitulating to an incredible amount of, inquiry to you about your client's case and what it really means. It's science, it's medical. The question is, should this man be able to file his case without paying his award of the government? And anybody with insurance would not be able to say, "Oh, I got a nodule, and That's fine. It's good. It's stable. And no, you would go out and get it. So I know he can't get healthcare, Cadillac healthcare, or Mercedes, or whatever you want to call it, any other car you might call it, but at least ought to have enough that's human dignity to be able to address serious chronic obstructive pulmonary disease is serious.
I agree, Your Honor. I mean,
okay, I just don't understand the way you argue the case, though, for the client.
Fair enough, Your Honor. We were just trying to set forth the similarities between his case and other cases in which there were serious injuries alleged. Do you want me to address redressability at all before I see my time?
Well, your time is up, but if you want to take a minute or so, I'll give you that.
Okay, thank you, Your Honor. So one of the questions asked, set forth by the district court was whether or not the claims under the Federal Tort Claims Act allow for Mr. Hall to obtain relief for the imminent danger set forth in his complaint. We would suggest that the court doesn't need to even reach that analysis, that there should be no redressability requirement because there's already an Article 3 standing requirement for prisoners to meet, such that the claims that there is relief available to him for the injury as set forth in his claims. And I'll go on to, I'll let the United States go and reserve my rest of my time.
Great, thank you, Mr. Croft. Ms. Reisenweber.
Good morning. May it please the court, Mr.
Yes.
Croft. Aaron Reisenweber on behalf of the appellee of the United States of America. If I may, Your Honors, I would like to begin by addressing the Article 3 standing requirement that counsel just brought up, seeing as he noted, as appellant noted in their reply brief, that the United States did not address the Article 3 standing argument in its response brief. And certainly there is a redressability requirement that comes along with establishing Article 3 standing. However, appellant's argument is that because Mr. Hall already has to meet that Article 3 standing redressability and has met it, that there should not be a further redressability requirement in making that imminent danger analysis. Significantly, appellant cites no case law in furthering this Article 3 standing requirement, except to rely upon those cases which set forth Article 3 standing. But the redressability requirement of Article 3 is quite different from what the United States submits is necessary in the imminent danger analysis under the Informa Pauperis statute. Because under appellant's argument, any well-pled complaint which meets Article 3 standing requirements would then also have that relation between the imminent danger alleged and the relief sought in the complaint. It happens to work in this case because we have a situation where Mr. Hall has brought a Federal Tort Claims Act, or seeks to bring that before the district court, and then his alleged imminent danger happens to be those same health issues of which he is complaining. However, should he have brought a Federal Tort Claims Act case and the imminent danger of which he complained was assault by the Hazleton Guards, then we have a situation where even if he were permitted to proceed in Informa Pauperis on that FTCA claim, the whole purpose of why Congress sought to establish this safety valve to the three strikes rule is undercut. Now, all
right, so can I stop you there, because I understand the purpose argument, and I think it's an excellent one to write your congressman about. But what I'm concerned about is where we're getting that out of the provision, right? So when I look at 1915G, it is entirely focused on the prisoner and his attributes, right? So no prisoner shall bring, right? Unless the prisoner has, right, referring to his past history, 3 prior dismissals, and then the prisoner is under, right? All of those focus on the prisoner and his attributes.
Yes.
At no point is there a reference or even an indication that the nature of the claim matters, right? So it's all about the prisoner and his state and not the nature of the claim. And so what I have a trouble with is the premise that you're operating under. I think actually both of you are operating under, which is you're saying that the nature of the claim must be related in some manner, right, to the imminent danger, right? That's what you describe as a nexus requirement. But I just don't see that. And I don't understand why. And then you want to debate about what's the scope of the nexus requirement. And you know, the challenge for me is I don't understand why there's a nexus requirement to begin with, right? Why does the claim have to relate to the imminent danger when the statute merely asks if the prisoner is under an imminent danger, not about whether his claim relates to an imminent danger?
Yes, Your Honor. And I guess that needs the answer to your question would then go back to a fair reading of why the PLRA was passed in the first place, and what the legislative plan was there, but not just that, what Congress's plan was in creating that safety valve in 1915G. So I think there has to be, or that Congress if you don't have that nexus, I mean, as this board,
So I agree. So maybe let me see if I can understand a little bit. So your point is they wanted to create a safety valve, and so we should read the last clause here as doing just that. And I fully agree with that. That seems to make sense. The question we have is, what is the scope of that safety valve? Right? Everybody agrees the purpose was to create one. The question is, what is the scope for that safety valve? Does it require merely that the prisoner be under an imminent danger of serious bodily injury, in which case they can file anything they want to? Or does the prisoner have to be in imminent danger and be raising a claim that somehow relates to that imminent danger? Right? Those are just scope questions. And I don't know how to use purpose there to determine the scope of the safety valve. That's maybe the core of my concern.
well, albeit as this panel has already noted, an unpublished opinion, this court in Myers noted that the imminent danger provision requires, and I quote, a relationship between the imminent danger alleged in the informa pauperis application and the facts alleged and relief sought in the underlying claim. And our argument would be then that, this court has already made a finding that there has to be a relationship, a nexus between the danger alleged and not just the facts alleged in the underlying claim, but the relief sought.
Counsel, maybe a simpler way of defining that would be to suggest that in the legislative prerogative that has set up this application process is that there is an attempt by the legislation itself to define what standing is in this context. And number two, that there are two ways that a prisoner could potentially get before the court. One from a general deterrence, so a general imminent danger, say they're pumping gas into the correctional facility. I'm not saying that's what's happening here. And one that is more particularized to an individual defendant and his or her imminent danger that might exist. Is that fair?
That's fair. And that is what the way the statute reads, is that the prisoner bringing the case is under imminent danger of serious physical injury.
And that could come from two factually driven contexts. It could be something that's happening to the prison population generally and something that's happening to the prisoner individually.
Certainly. But I think that the whole purpose that Congress intended in providing the safety valve, as another court has said, and as the Myers court reiterated, is swallowed if, in fact, that imminent danger cannot be addressed by the relief sought. So if he brings an FTCA case and is seeking to proceed in form pauperis because of lack of medical care, but is, as his imminent danger, alleging assaults by prison guards, then allowing him to proceed on the FTCA claim in form pauperis doesn't ensure that that prisoner is then removed from that imminent danger. And then that's why the redressability prong becomes so important. The United States would
counsel when you start getting into the weeds that way, then you're almost requiring a mini trial, aren't you? You're requiring us to look at the merits there, a lot of determinations. And shouldn't we be, as I think Judge Richardson's question to you, since that, or at least one of the options it was given, to look at whether or not there's imminent danger as to the person who wants to bring this without paying the filing fees. That's all. But there's nothing to suggest that we have to do a mini trial to determine whether or not it's going to be, he's going to win, or with redressability. Those issues are, they're intertwined with merits, aren't they?
I believe it's a simpler question than that, Your Honor.
Well, how could it be simpler in terms of, maybe simple way to answer, but don't you have to get into the merits to some degree for that?
I think it's an easier question of if there's a favorable ruling, using the example that I just put forth, if there's a favorable ruling in an FTCA claim, is that going to redress or address a situation of imminent danger regarding assaults by prison guards? No.
Yeah, he would get some money, and he could hire a physician to he could pay for his procedure he wants done.
I'm not sure that's a realistic possibility.
Why not? Why wouldn't it be? If you can afford, you mean to tell me you're a rich person, you're in prison, and you can afford a transplant, and we would deny it because you're in prison. You can't use your money to get a transplant that you're going to pay for?
I have to tell you, Chief Judge, I don't know the answer to that question. I do not know.
Well, there's a reason why we don't know, because we don't have a trial yet to determine whether or not he's going to get any money and determine what he can do and use the money for. That's what I mean. It's very intricate if you start getting down the path you're trying to lead us to.
Well, in this case before the court, the United States would submit that Mr. Hall, as the district court correctly found, has not established, given the facts, lack of facts presented, that he is in fact under imminent danger.
Oh, well, fair enough. That's your position. I understand it. But we're back to questioning whether or not he's met that standard. But when you start talking about, well, it's not redressable, then therefore we ought to look ahead and determine it's not going to be redressable, as opposed to just sticking with the order of the day. Is he in imminent danger?
I'm sorry, I'm not sure.
No, I'm just, no, go ahead, counsel. You can, you've answered my question, I think.
Okay.
Do you have an argument, counsel, based on the medical records that we now have before us, that they fail to show that COPD and assorted respiratory issues, which I think is what your colleague pointed to, that those don't show an imminent danger of serious bodily injury. I mean, there's discussion that he had difficulty breathing because he had the flu, right? And at some point, and that as a result, he was coughing up things. But that sounds like the flu in 2019, not something else. I guess what I'm having trouble with is finding in these medical records any suggestion that his respiratory issues, asthma or otherwise, are an imminent danger of serious bodily injury, whatever that phrase is to me.
Your Honor, I was going to start my argument with a statement because I became concerned when I heard about the medical records. I am not in possession, nor have I received any of these medical records. All
right, so just check ECF, right? They were filed, but that's totally fine. I mean, I understand sometimes we don't keep up with what's filed in the court, and that's fine. If you don't have a comment on it, I'm totally fine not hearing from you on it. I just wanted to know if you did what it was.
No, I do not, sir. And for the record, I don't know whether they were filed under seal, but I get all of my ECF records and recently checked the docket, and I have not received notice of the filing of the medical records. And I apologize if I indeed have overlooked something.
Counsel, if I could follow up on a question by the Chief Judge, and I think that the direction that he was trying to take you is to the analysis as to how the Myers case may impact the determination that this court needs to consider. And I'm going to read you something from Myers, and I want to get your perspective on it. It says, the Myers court concluded that the imminent danger provision requires not only a relationship between the imminent danger alleged in the informal pauper's application and the facts alleged in the underlying claim, but also a relationship between the imminent danger alleged and the relief sought in the underlying claim. Without explicitly saying so, the Myers court noted that the end result of the underlying claim must relate to the allegations of imminent danger. Do you agree or disagree with that analysis from the Myers case?
I do agree with that analysis, Your Honor.
Okay, and if that is indeed the case, why wouldn't we need a record to establish that connection between the underlying claim and the allegations of imminent danger? Why wouldn't we need a record to make that determination as to whether that circumstance was addressed by the district court?
Why would we not need a medical record?
No, an analysis of some sort to get us to the conclusion that you're trying to help us reach.
And you're saying in regards to the order that was entered?
Yes.
Yes, in this case.
Yes, ma'am.
I don't disagree with that, Your Honor. The district court in this case reached a conclusion that perhaps needed to have been fleshed out a little more completely.
And then if that's the case, why wouldn't a remand be more influential, for lack of a better word, than just taking your position fully?
Because at this point, we would still argue that he had not, in what was submitted to the court, established that he was in imminent danger. And then that redressability analysis that you just walked through there.
I think from listening to the questions that you heard from the court seems to almost recognize that there was a consequence, not necessarily defining it as an imminent danger, but a consequence that needed to be addressed. And the consequence needing to be addressed then leads us to whether or not there's an imminent danger and whether the relief sought has a nexus between that. And with this record, can we make that determination?
I'm not sure that I understand the question or the use of the word consequence.
When I'm talking about consequence, I think we all recognize that the gentleman had some medical issue. Can we at least say that?
Yes, Your Honor.
Okay, and so next we go to the question is whether or not that medical issue leads to the determination of an imminent danger.
Yes.
Okay, and then once we get that, we have to take another step to determine whether the relief sought relates to that imminent danger.
Correct.
Okay, and so if we have to do all of those things, does this record allow us to do that?
Well, as we noted, you can make that fairly traceable. It is related. He's alleging that the imminent danger is, all of these health issues, alleged health issues. And then the relief sought is that he wants monetary damages for this alleged lack of medical care in regards to all of these health issues. I think that part is fairly straightforward. What the district court did then was take a further step without citing the Pettis case, but then asked, because, does a monetary award here, is it going to address this imminent danger when this individual, A, is not going to have past or future medical expenses that he will have had to occur, which a lot of times in a healthcare tort case is the remedy sought. An FTCA case cannot offer injunctive relief to the inmate. And this does go to Chief Judge Gregory's question, to which I do not know the answer, whether a BOP inmate who has the monetary means to do so can even seek outside medical assistance. If there are no further questions from the court, we simply ask that this court affirm the district court's ruling, as Mr. Hall has not, on the facts alleged, established that he is in imminent danger. And even if he had, he cannot establish that the claim he is bringing will redress any allegation of imminent danger. Thank you.
Thank you, counsel. Mr. Croft, you have some time reserved.
Yes, Your Honor. Thank you. I just want to pick up on one of your points with respect to the redressability analysis and the complications that brings. That, we highlighted this in our reply brief, is that the difficulty of determining whether or not claims presented by prisoners will allow them to obtain the relief in order to escape the imminent danger of serious physical injury, as the district court put forth in this case. And I think part of the issue is that is a complicated analysis that does require a look at the entire record. It has to go beyond just the allegations in the complaint and possibly testimony or other medical information that may be helpful in determining that decision. So I would agree, and we would set forth that redressability is not should not be a part of the analysis. It should solely be whether or not the prisoner has met the imminent danger of serious physical injury standard in order to seek the fee waiver under the Prison Litigation Reform Act.
Hey, counsel, can I ask you again? I want to sort of think about the record, and that's both the joint appendix and docket entry 5, which is the medical records that we were talking about earlier. Where do I go if to find the best indication to you from your perspective that his COPD and associated respiratory issues were so serious that they posed an imminent danger of serious bodily injury? Not the legal standard, whatever that means, but what am I looking at? Because I see in his complaint, he makes the bold assertion that I'm in an imminent danger, and I assume that's not enough. Using the medical records we've got and or the complaint or affidavit, however we describe it, what's the best evidence that supports not just that he has some respiratory issues, but that they're that serious?
Sure. I would point the court to joint appendix pages 11 and 12. Those highlight some of the issues, I think, in the best manner by Mr. Hall. In particular, Joint Appendix 12, he states that the Bureau of Prisons ignored his repeated requests for pulmonary consults, and also ignored his complaints that the medications that he was on regarding the COPD and asthma were not working.
But counsel, again, I think Judge Richardson's question was a little bit more precise than that. Those are your client's assertions. What is there in the record to support this evidentiary determination that you would ask this court to reach?
Fair point, Your Honor. Mr. Hall did not include his medical records with respect to his complaint at the time he filed his application for the fee waiver at the district court level. In terms of what was before the district court, this is solely the record. Now, if there are additional records that were set forth to the circuit court, and that those records can be considered by the district court on remand, I would suggest that that would be the appropriate step.
Yeah, the United States has control of those records, correct?
My understanding is yes, the Bureau of Prisons would have Mr. Hall's medical records.
Absolutely, every one of them. I don't think there'd be a HIPAA problem either.
I believe he would execute that, Your Honor.
Yeah, I think so too.
He filed. I mean, he had them, and he filed them with the court. I mean, you know. Now, maybe the thought is that this isn't all of them. I don't know. Anyway, I understand your position. Thank you.
If there are no further questions from the court, we would ask that the court remand the case to the district court for further review of the application for the fee waiver based upon the imminent danger of serious physical injury set forth by Mr. Hall. Thank you.
Thank you, counsel. Thank you both. I note, Mr. Croft, that you were court appointed, and I just want to give you a special thanks on behalf of the Fourth Circuit, because we depend on lawyers like yourself to take these cases and help us on these issues. We really appreciate that. And obviously, Ms. Reisen, however, also your representation of the United States. We can't come down and greet you, but know nonetheless that we really appreciate your being here. We hope that you will be safe and be well. Thank you so much.
Thank you all. Thank you, Mr. Croft.
All right, we'll proceed to our next case.
Of law, and it's my pleasure to introduce Mr. Ignacio Martinez and Ms. Hannah Comeau, who will be presenting argument for Mr. Firewalker Fields. Mr. Martinez will handle the opening argument, and Ms. Comeau any rebuttal. Thank you.
Thank you. We'll hear from the Cavaliers now. Mr. Castellano?
Good morning, Your Honors, and may it please the court. Your Honors, the district court erred in granting summary judgment to defendants in at least 3 ways. First, it granted it prematurely, before appellant had an opportunity to seek discovery and after placing the court on notice that discovery was necessary. This court recently made it clear in Pledger that it is an abuse of discretion to grant summary judgment in these circumstances. And Your Honors, we think that the briefing on appeal has made it clear that there are many important unanswered questions that could not have been answered without that discovery. Second, in applying Turner to the free exercise clause claim, the district court failed to consider easy and obvious alternatives that a trier of fact could have seen immediately indicate that the jail's policies are unreasonable, are exaggerated. And third, the district court applied the wrong standard to the Establishment Clause claim. It applied Turner and thus collapsed the Establishment Clause into the Free Exercise Clause, rendering one of them redundant in the prison context. That's something that no court of appeals has endorsed, and the Supreme Court gave us the right test in Cutter v. Wilkinson. Your Honor, starting with the first error, the discovery issue, this court recently held in Pledger that it is an abuse of discretion to grant summary judgment before discovery, even in the context of a pro se litigant who never formally requested it. Fireworker Fields.
Martinez, let me ask you a question, and I compliment you on your ability to appear before the Fourth Circuit. When I was in law school, I was scared to appear before my professors, so I want to compliment you and the people who have been able to bring you to this point. Well, let me ask you a question, sir. I know that you rely on the Pledger cases to the context of when summary judgment should be granted, but isn't it true that in this case, that many of the discovery issues that are presented can at least somewhat be attributed to discovery violations on behalf of your client?
We don't think so, Your Honor, because the district court set a 75-day mediation schedule, after which the defendants were directed to immediately file for summary judgment. And we think that it was perfectly reasonable for Fireworker Fields to assume that discovery could not have happened during that mediation schedule. And the discovery that he requested was depositions, and as an incarcerated prisoner, he was not allowed to seek that discovery without leave of the court. So we think that, as the court found in Pledger, the plaintiff in that case was not at fault in not being able to gather the necessary evidence. Fireworker Fields similarly was not at fault. And we also think that Fireworker Fields gave the court appropriate notice. He requested that discovery, and if he had gotten it, the record would look very different. We would have real factual testing of assertions by defendants that on their face just don't make a lot of sense. For example, how can it be impossible for the jail to supervise a group Friday prayer when at the same time they assert that they would have been more than happy to supervise individual visitation between an imam and Fireworker Fields and presumably the rest of the Muslim inmates if only they had been able to find one? Or how can it be that in 2021, where these services...
Let's just take that example, right? I mean, I've got a little trouble with the he seeks on the free exercise claim communal Friday prayer, and yet we know that he cannot have a group meeting, right? Because of his, or could not, I should speak in the past tense because he's not there, but he could not because of his security classification. And I don't take him to challenge his security classification, nor I suspect would he be very successful in doing so. But so how can he really complain about the communal aspect, right? We have a case called Wright versus Lassiter that suggests that if you're seeking a communal, but you can't be in a community, then you have not stated a free exercise claim. What am I missing on at least on this piece of your free exercise claim? Maybe there's a different piece.
Yes, Your Honor. So he does have access to the day rooms. That's where the Christian services are being provided. So that communal aspect can be satisfied with something similar. Group Friday prayer on Fridays in the day rooms where the communal aspect, the congregational prayer aspect can be satisfied.
So good. So that's one step. So not sort of a private group like we've talked about with some of the other groups, but he says, okay, well, I can do it just like the Christians are doing it. The problem there is that the prison has said, we only do that with donated videos, right? And, that seems like a reasonable position given the sort of play in the joints between free exercise and establishment, having officers be the ones that are choosing what Muslim videos or prayer services to play doesn't seem like a grand idea. And yet we know from the record that no prayer services were provided.
Yes, Your Honor, and that's exactly one of the policies that we're challenging as too narrow under the free exercise clause, because we believe that
you're challenging the decision of the prison to not create its own prayer services, to rely on outside groups.
No, Your Honor, just the narrow issue that they will only accept services donated by a local group. Because we think that a prior effect would be very entitled to find that these services can be downloaded or live streamed from the internet.
Well, they're not saying a local group, right? They're saying we can't choose them. It has to be an outside group that's choosing them, right? Because, they're in this like tough spot, right? Between free exercise on one side, but establishment clause on the other. And so if the warden is there and he's like, oh, this is the message I want to send, the Muslim prayer message, I'm going to choose this Muslim message, not that Muslim message. We might start to think that looks a lot like endorsement, right? So the warden is the one making decisions about what prayers or verses of the Quran or whatever it might be is being offered. And that strikes me as, and I think you would agree, sort of broadly problematic, maybe not unconstitutional, but problematic at least. And so is your position that the prison cannot make that decision? So they can't say, no, we're not going to be the ones picking the prayer services. We're not going to flip through the Bible and find the Bible verses on which, the video is going to be about. The guards aren't going to make the videos.
Right, Your Honor, we think that would be completely fine, especially because of that space in between the joints of both clauses, because context matters in the establishment clause issues. And I think defendants made that point in their briefs as well. And if the jail was to offer a Muslim service on top of the Christian service, then both the coercion and neutrality concerns would be alleviated, because the whole context would be that the jail starts accommodating more than one religion. So even if
but I understand that, but what my point is a causation problem, right? So they've said we only do that if they're outside groups that give us these videos. No outside group gave a Muslim video. Ergo, their action did not cause a free exercise problem, right? That's Wright versus Lassiter, right? So that's the rub I'm getting at. Now, if there was a video that had been submitted and they chose not to play it during these 82 days, right? We might be in a different spot, but that's not where we are, right?
I think, well, Your Honor, these services are available online and they have been uploaded and donated by mosques.
So let me reframe it to make sure, because you're just trying to avoid the question, and reasonably so. I don't mean that as a critique, but the point of that being is that your position is that they should be required to choose the prayer services, that the warden should be required to go online and pick and choose among prayer services.
That's right, Your Honor. They can either pick one of those or let the Muslim inmates pick. We think both of those are suitable alternatives.
Doesn't that undermine the whole policy of exercising your faith? Not all Muslims come from the same perspective. And so if you have one group of Muslims, I think in this case they're Sunnis, who have a different point of view, philosophically, spiritually, from another group, then the other group is going to complain that this is an imposition of Sunni principles and not the principles we want to live to. And so then we run into the problem that I think Judge Richardson is trying to articulate. Isn't it up to the individual prisoner to identify the means and circumstances as to how his faith is to be communicated in a prison setting?
That's certainly correct, Your Honor. But I think at the baseline of what the free exercise clause requires, and similarly to how the Christian inmates get a Mennonite service, in this case, we could have one Muslim service for Muslim inmates. And yes, in that case, you could run into the potential of some inmates not completely identifying with that service. That's right. And next, moving up, well, lastly, Your Honors, we think that Firewalker Fields did place the court on notice by requesting discovery. There was no real reason for the district court to deny that motion to seek discovery. And so it was abuse of discretion on the pleasure to grant the summary judgment before that discovery could take place.
Would any of the discovery requested have gone to the issue that I'm concerned about, right? The idea that it is a reasonable decision to require outside groups, accept that as a hypothetical, and that no Muslim group submitted videos and therefore whatever harm came to your client by lacking videos was not caused by the jail or prison, whichever one it is.
We think so, Your Honor, because in his motion to take the positions, the first three people he listed are Sussex One officials, the Virginia Department of Correction officials. And we think that the only reason why he would have wanted to talk to those people is because Sussex One did accommodate his Friday group prayer requirements. So we think that the whole purpose to seek the positions of those people was to explore alternatives on how a jail could accommodate this requirement.
But counsel, we're not really talking about a circumstance where there's not some reasonable effort being made by the prison to address your client's concern. From what I understand, he's got dietary considerations that have been taken into consideration. He has a prayer rug, which I understand is part of their faith component. And they've done other things to allow him to exercise, for lack of a better way of putting it, his religious principles. So this is not a case where someone is necessarily being denied his ability to exercise his religion, is it?
We think it is because the Jammuah congressional prayer requirement is crucial to his faith. And he made that clear in document 3 of the docket entries that failure to comply with that congressional prayer requirement can rise to the level of him being considered a non-Muslim. So we think that that group prayer requirement is a crucial ingredient that is missing in this case.
All right. So why isn't, you'll agree, I assume, under Taylor, et cetera, that they don't have to do everything somebody asks. And they give him an option to have a Friday prayer with Imam, right, who visits him, right? And it's a group because there's 2 of them. I assume that's a group. And that's a manner of doing it, right? It's not the one he wants, right? He wants to do in person, but he can't do that because he's in max security. Maybe he wants to do it on video, but he can't do that because nobody's satisfied the requirement of submitting videos. So why isn't that the reasonable accommodation of his free exercise to allow him to have Friday services, a Friday prayer with Imam who visits him, but which he did not, he didn't put anybody on the list. So it's hard to say that the jail caused that problem either.
It's because the challenge under Turner is as to the reasonableness of the policies. And under Turner, we think that the fact that there are easy and obvious alternatives, such as, for example, that there could be an exception for him to lead a group service. This court in the Jehovah case made it clear that exceptions to blanket rules can be easy and obvious alternatives.
But isn't it clear from the record that taking a look at his ability to actually lead a prayer service is antithetical to the prison policy, because in certain circumstances you have individuals in gangs and the like who are using those kinds of contexts to do things that are not consistent with religious principles.
That's right, Your Honor. That is their legitimate asserted concern. But what we're missing here is the reasonable relation between that concern and the policy that they have. Because in the Jehovah case, this court said that an exception to the blanket rule, in that case, the ban on alcoholic beverages consumption, an exception to that rule for just a religious purpose could be an easy and obvious alternative that could comply with not be in conflict with their asserted concern. Similarly here, we see no reason why a narrow exception just for the purpose of a Friday congressional prayer could not be afforded to him, especially he made it clear that he was qualified to lead those services.
Can I ask a jump over a little bit because your time's running out and sorry we've taken it up, but if hypothesize that I'm looking at Lemon for your Establishment Clause case, and I'm looking at the first step of Lemon, which is, whether it's a religious purpose, why shouldn't we say that the purpose of playing the Christian video is not a religious one, but is instead a compliance with constitutional principles purpose? And I take that from Cutter and maybe also from Taylor. Why is that not the right way to think about step 1 of Taylor? Of Lemon under the principles that Cutter announces?
So, Your Honor, the jail has asserted that it is that the policy was done pursuant to the free exercise clause. But we think that in this context, because they have refused constantly to accommodate any other religion, that a trier of fact would be entitled to find that purpose is not really what it seems.
All right. And so the question there is, there's no allegation that any other group submitted a video, right? I mean, this goes back to the question. I understand you think the warden ought to get to go pick which videos to play, but assume hypothetically that it's a reasonable decision to say we need an outside group to pick them so that we walk this line between free exercise and establishment. If no group has submitted a video, can we say that the decision, that there has been a decision by the jail or that its policy is what caused that imposition?
We think we could still say that because, yes, certainly, there's a lot of interplay between the free exercise clause and the establishment clause, but the analysis still remains separate. So even if hypothetically the policy is found reasonable under Turner, I think we could still make the argument that the purpose behind it, the Christian services policy, is nefarious. And lastly, Your Honor, just a really quick point. We think Cutter applies because what the question that the court answered in Cutter was, what does that space in between the joints of the free exercise clause and the establishment clause look like? That is the question that the court answered in Cutter, and appropriately it's focused on the core establishment core concerns, which are neutrality and non-coercion. So that is why we think Cutter should apply. And under Cutter, we think that he has presented a triable claim, because in this case, there is no.
Can I ask one follow-up to that? I'm sorry, Chief.
Sure.
Am I understanding you to say that you think Cutter supplants and or overrules Lemon? Or are you saying that we should apply the Lemon factors in light of Cutter?
I think that in this case, in these particular circumstances, because that is what we're looking at, it's state action that goes beyond what the free exercise clause merely requires. And what we're alleging is that it makes that jump in between those joints and then starts encroaching into establishment clause territory. That's the question that was presented in Cutter. So we do think that Cutter would override Lemon and Lee in this case, and just provide independently the test that the court should be applying.
Thank you.
All right, thank you.
We'll certainly welcome any more questions, Your Honors, but if there are none, we would like to reserve the rest of our time.
Thank you so much.
Thank you very much.
Mr. Hart.
Thank you, Your Honors, and may it please the court. My name is Julian Harf. I'm here on behalf of the Middle River Regional Jail Authority and the Superintendent of the Jail, Jack Lee. Your Honors, our position is that the district court properly granted summary judgment to the jail and the superintendent. I want to jump right in here, Your Honors. There was a lot of discussion about the fourth factor of the Turner test as it applies to the free exercise clause, that being whether there are obvious or easy alternatives to the current religious programming that's offered in the jail. Your Honors, as an initial matter, Firewalker Fields asked for one specific thing from the jail. He asked for an inmate-led service. This idea now that discovery would somehow change that is simply incorrect. What Firewalker Fields wanted discovery for was to develop evidence about whether he had a sincere religious belief as to his Muslim tenets. The discovery had nothing to do with figuring out potential alternatives to the current services that are being offered at the jail. Now, on top of that, even if we did go back and get discovery now, he's no longer at the jail. We are now in litigation. What he was required to do was to give the jail an opportunity to address the alternatives that he provided. So even if we went back and now in litigation did discovery about those alternatives, that wouldn't solve the issue, that the key issue that he did not take his proposed alternatives to the jail. The only alternative he took to the jail was a potential for an inmate-led service, which, as we stated on brief, was not feasible due to the policies that the security issues, in that we don't let inmates lead services. We don't let inmates lead any activities, for that matter, for security purposes. And all of our activities, secular and non-secular, are provided.
I'm sorry, wait, can you back up 1 second?
Yes, Your Honor.
The last, I just missed it because I was thinking about something else. Did you say you allow no inmate-led services?
Yes, Your Honor. It's provided even-handedly across all secular and non-secular activities. We do not provide any inmate-led activities, whether that be religious or non-religious. Now, the reason behind the fact that the discovery wouldn't help Firewalker Fields in this matter is that the burden was on him to present these alternatives to the jail. That is what was developed in Turner. What the Supreme Court said in Turner is that it rejected the notion that prison officials have to manufacture and then shoot down every conceivable alternative method of accommodating the claimant's constitutional complaint. And Your Honors hit on it. The basis for that is that prison officials, particularly here, where we have a local jail in Stanton, Virginia, they are not equipped to make determinations as to what is the best way for a Muslim inmate or an inmate of any minority religion to be celebrating that religion, to be worshiping that religion. They simply don't know. And frankly, some individuals among the same faith worship differently. So it makes sense that the burden is on the prisoner to come forward with those proposed alternatives. Here, Firewalker Fields came forward with one. It clearly wasn't feasible. It was not in line with jail policies, and therefore we didn't do it.
Yeah, but alternatives is a little more granular than that, because you're saying, for example, you put forward that part of your restraints are economics, correct?
Yes, Your Honor.
Well, when you need discovery to say, well, how much money are you spending on this? You claim that it'll be a burden, but I want to know, how much do you spend on this? And in this record here, it looks like little or nothing, correct?
That's correct, Your Honor. So that's why we have everybody coming in on a volunteer basis, is to preserve finances.
Okay, all right. Now, am I right? The time span is about an hour and a half?
I believe it's 30 minutes for this particular.
No. This time span for this period where you have this time where they have in the work area.
Yes,
right?
I believe that lockdown period is about an hour and a half.
About an hour and a half. So then, and you say about 30 minutes is what you have for the non-denominational Christian service, correct?
Yes, Your Honor.
What I understand him to say is that, well, there are videos that are available, obviously led by the appropriate official in terms of the Muslim faith or Islamic faith, right? And for example, why couldn't you play both during that hour and a half period?
So at a base level,
because you only have one monitor, I understand that. So you have half an hour this service, the next half an hour their service.
Yes, Your Honor. And so at a base level, we can't do that because we've had no one volunteer to give us that service. So we have reached out.
No. That's what the beauty of the internet. You search it and you find that this is for example, in COVID environment, you can search a lot of church services around the country now and say, I like to hear what the Baptist church in Los Angeles is doing. And you can hear that sermon, okay, for example, or you might hear a synagogue service or a temple service. The point is, why is it you can search it and say, oh, here's one right here. That's the very communal prayer that he's talking about. Let's play that. You're only playing one, so you wouldn't bother that's only one person listening to it, right?
Your Honor, so I think that makes an assumption, a couple assumptions. One, that is we have the capability to do it. So as I think you alluded to earlier, we have a closed circuit TV system. Frankly, because that alternative was never put forward by Firewalker Fields, there was no evidence in the record as to whether that's a feasible alternative.
But it's put forward automatically by your response to his litigation. Well, we only have one monitor. Nobody's come forward. We searched the local area. We couldn't find. You have, you can't use it as a sword and a shield. I'm out here doing it, but I can't go to the internet. Well, why couldn't you?
Well, Your Honor, I don't think we're saying we can't go to the internet. I think what we're saying is as we currently have it, it's provided by a DVD. The Mennonite service is provided by DVD. It's played in a closed circuit TV system throughout the jail. So for this
You're
particular,
making my point now, right? It's a DVD, and that's an old way. The new one is streaming. Stream, that's new. Y'all still use DVD? No, I'm sorry. But you can stream these things now.
So I think what that gets to is, okay, so how are we going to stream it? I don't deny it all, and I think it'd be foolish for me to say we can't stream it. We could find the stream, but then the question is, how do we implement it? Okay, so right now, our system does not allow us to stream something from the internet into the closed circuit television. So then you're talking about purchasing a device for these inmates to use.
A laptop?
Potentially a laptop, potentially a tablet, but then you run into questions of administration, Your Honor. So we don't allow, of course, unfiltered access to the internet in this jail. We're in prison.
It's not unfiltered. You would be the person totally in control what goes on that monitor. Only you. There's not a thing that inmate can put on that screen other than what you allow it to be streamed to. And what he's saying is that you have an hour and a half period time. You got an hour left. Anybody who doesn't want to hear that service, they can, like you tell him, go back to your cell. That's what you tell him, right? Am I right?
Yes, Your Honor.
Well, wouldn't the same thing be told everybody else? If you don't want to hear this one, go back to your cell.
So I think that's assuming we can do the streaming service on the current system we have. And I don't think that's possible. But even
what's the second assumption? So go to you said there are multiple assumptions.
Yes,
Assumption one is capacity or capability.
Yes,
what's number two?
So the second assumption is that then every other religious group at the jail is going to make the same determination.
But we can only have one case at a time. I mean, for example, when cases that came before that people talk about saluting the flag and we didn't say whether or not because it was done by one Christian sect that, well, somebody else might want that. We take these cases because we don't give advisory opinions. Article 3. What's before us is what before us. It's his case. Now, there are implications, obviously, in policy and looking at, but that would be, you can't raise that red herring. You could do that in everything.
Your Honor, so the case law does say that we are not required to provide equal accommodations across the board without any consideration as to inmate demand or resources. What we are required to do is to provide reasonable accommodations. Sure. So with the alternatives that we provide, with his ability to have an imam come pray with him, with his ability to have a prayer rug in his cell, with his ability to have a Quran in his cell, with the ability to have the diet that he wants, with the ability to have the Ramadan meals that he wants, we believe we have provided reasonable accommodations. Now, I do think there is precedent to say that ripple effect I was talking about is legitimate. There have been cases that have said that alone, for example, was one.
But isn't bottom line from your perspective that the relief specifically and particularly that this individual has requested is not something that's available to any inmate? He wants to lead his own services. That's what he wants to do. Yes, and are you suggesting to this court that accommodation of his religious request is inconsistent with penal policy, the policy of your particular institution, and it's consistently applied to anyone and everyone who makes that particular request? Now, there may be subsets of what could happen, and maybe if in the context of his complaint he had asked for those things, we would have a different case, but he is asked specifically to be allowed to lead his own services. Is that correct?
That's exactly correct, Your Honor. What he has asked to do, the only thing that he requested on the record was an inmate-led service, and we cannot do that for the reasons we've discussed.
Would we have a different case if in the context of the disposition of this case, he had, say, amended his complaint or amended his request and say something that is less arduous, for lack of a better way of putting it, where he's saying, what I would like for this imam who I've identified to be able to come to the jail on certain dates and be able to share with me and anyone else who might request. Would that be something that you would be required to accommodate?
So I think that's a closer question. I think right now he can get a form of that by having the imam come for himself. I do think, so the ripple effect I was discussing earlier, I think there is going to be a question of that. Right now we're talking in hypotheticals, depending on exactly what he asked for.
But right? Your bottom line is the nature of his broad request, the context of this case is what is fatal to his case.
Yes, Your Honor. That's exactly my position. And as you hinted at, there might be certain modifications that could work. I think we've already provided them, but there is a consideration of resources and demand that we have to take into account, because otherwise, then you're getting an inevitable situation that we would not be able to accommodate. And then you're favoring some groups over others, and that, of course, is going to lead you into constitutional.
Let me ask you a final question, and I'll shut up. What if, in the context of this case, if he had been allowed to pursue his discovery without the confusion of whether the mediation trumped it or whatever, if he had the opportunity to pursue his discovery, he might have come to the conclusion that a more or less arduous accommodation would be something more appropriate and would lead to the resolution of the case.
Your Honor, that is not what's in the record. So in his discovery, what he asked for had nothing to do with reasonable alternatives. It had to do with another question, which is his belief actually real? You know, does he have a true belief, a Muslim belief? And
I'm not doubting you, but as an officer of the court, you're saying there was nothing in the discovery that talked about reasonable accommodations.
From my understanding, no, Your Honor.
Okay.
No.
All right. Thank you.
Your Honors, I do want to move on to the Establishment Clause portion of this argument. If there are no further questions, of course, we would ask that you affirm the ruling of district court on the free exercise claim that the jail was entitled to summary judgment. Now, of course, we would ask the same, that you affirm the granting of summary judgment on the plaintiff's Establishment Clause claim. And it's our position that the court properly applied Turner when deciding whether the jail's policy of broadcasting a Mennonite service and not having a Muslim service violated the Establishment Clause. Now, if you look at the Supreme Court case law, Shaw versus Murphy, for example, the Supreme Court has expressly held Turner provides the test for evaluating prisoners' First Amendment challenges. You then have Johnson versus California, saying that Turner applies to all constitutional claims by prisoners involving rights that must necessarily be compromised for the sake of proper prison administration. So this is not a free exercise test. This is a test that applies to all constitutional rights in the prison setting, unless it is something that can be compatible with the prison setting. And it's very clearly seen when you talk about something like the Eighth Amendment, right? So in the Eighth Amendment context, you cannot have an officer in a jail that beats someone up for no reason. That's going to apply whether inside or outside prison walls. However, when you're in prison walls, you cannot practice your religion whenever and however you want, because you're inside a prison. There are restrictions upon you. So this is exactly the type of case where Turner should apply. Now,
but that's where accommodation has to occur. You don't have carte blanche to do anything that you want to do in the exercise of religion, but it has been recognized through precedents of this court and the Supreme Court that the institution must make a reasonable accommodation to your religion, because everyone has that right to exercise their point of view spiritually.
Yes, Your Honor. That's exactly what we're saying. We are saying that Turner applies to this case in that we must provide reasonable accommodations for individuals incarcerated to practice their religion. And it's our position that what we have provided Fire Walker Fields is reasonable.
So can I ask a maybe esoteric question? So I very much understand your point that Turner applies in the Establishment Clause context the same way it does in the free exercise. Maybe not the same way, but it certainly applies. Is that affected at all by Cutter? Because Cutter, you might read Cutter and its application to this sort of play in the joints between the Establishment Clause and free exercise clause is sort of being the same idea, or at least a version of the idea of Turner, right? That they're in effect the same principles, different words, but same basic principles, that they're trying to allow this play in the joints. Is that a reasonable way to read Cutter as sort of not supplanting either Lemon or Turner, but instead helping us understand how to apply the precepts of Turner in the Lemon context?
Yes, Your Honor. I think that's exactly how you should read Cutter. So when you just read Cutter, when you read the case itself, it is not clear that Cutter is trying to derive a new test. Just the language of the case does not, there's nothing like, okay, here's factor 1, factor 2, factor 3. There's nothing like that. Whereas there is in something like Turner. It's very clear that Turner was trying to establish this test. Okay. What Cutter addressed was whether a general act of legislation, RLUIPA, was constitutional. That's the confines of Cutter. We have a more narrow case in Turner that specifically looks at what we're looking at right here, which is what is the constitutionality of a specific prison policy as applied to this prisoner? That's what Turner looks at, specific policies within prisons. And that's why Turner applies in this case. Now, to your point, Your Honor.
And is that, so should I take that to mean, sorry, no, you'll come back to your point. do I take that to mean that the point in part of Cutter, as I think about Lemon and Turner, is that accommodating the free exercise of detainees is not a religious purpose for Lemon ideas, right? That in fact it's a constitutional purpose. It's compliance with constitutional dictates. That's sort of what Cutter seems to suggest to me. In that context, that's a statute, this is a policy, but the principle would seem to be the same, that complying with their constitutional obligations to permit the free exercise does not, at least in many circumstances, thereby create an establishment clause problem.
That's right, Your Honor. So what we are required to do by the free exercise clause in prison is accommodate the free exercise of religion. So that's exactly what we're doing here. That's the secular purpose. The purpose of what we've done is to accommodate, in this case, the largest faith group at the jail, but we've also accommodated everybody at the jail. So the purpose here is not to endorse Christianity. The purpose is to do what we're required to do, which is to provide the exercise of religion. And I want to point out a specific portion of Cutter that essentially gets to what you're talking about, Your Honor, which is that Turner does not supplant, or Cutter does not supplant Turner, but can be read in conjunction. And these other Establishment Clause tests, particularly Lee and Lemon, can be read in conjunction with Turner, similar to the current qualified immunity standards, where you first determine you can determine in either order, but is there a constitutional violation? And if so, was the law clearly established? So here, Turner, of course, is not a Establishment Clause test. It is a test looking at specific prison policies and whether they are reasonable. So you can do an Establishment Clause analysis and also do a Turner analysis. Those two things can be read in conjunction. And I want to point you to a specific part of Cutter that goes towards this. So the court said in Cutter, we do not read RLUIPA to elevate accommodation of religious observances over an institution's need to maintain order and safety. Our decisions indicate that an accommodation must be measured so that it does not override other significant interests. Lawmakers supporting RLUIPA were mindful of the urgency of discipline, order, safety, and security in penal institutions. They anticipated that courts would apply the Act standard with due deference to the experience and expertise of prison and jail administrators in establishing necessary regulations and procedures to maintain order, security, and discipline, and consistent with consideration of costs and limited resources. That right there, Your Honors, is exactly what Turner talks about. It's talking about keeping in mind resources and the specific context that the jail is in when promulgating these policies.
I got one final question since you're out of time, if the chief will allow it. So I'm still worried a little bit about this interplay, right? And so I know this is not the case. This is a hypothetical question, right? So accept that as a given. Would the analysis be different under the Establishment Clause here if the warden was the person who was picking the videos? So if the warden was saying, I'm really, I'm a fan of this particular Christian message, and so I'm going to pick, services that talk about redemption, right? Because the Christian ideals of redemption are ones that I want to promote, and so the warden is the one making those choices. Would that affect us as we start thinking about either the Cutter, Turner, Lemon analysis? How does that play in?
Yes, Your Honor. So I think that is closer to endorsing a religion, right? Because then you have a warden who is specifically saying, I want this type of service. So instead of accommodating the reality that we need to provide free exercise of religion, he is now reaching out based on content and saying, I want this, rather than in this specific scenario where all we do is we have volunteers come in and provide what they can. We're not making any determination as to what's better or worse or what we want and don't want.
So the safe harbor is to do nothing and let the prisoner take control of what types of services he or she wants and allow the prison officials to decide whether it's consistent with the policies of the institution under all the circumstances presented.
Yes, Your Honor. And to take into account the resources of the jail, the population, the demand, and things like that. Yes, Your Honor. And with that, if there are no further questions, we would ask that you affirm the decision of the district court.
Just one thing before you go.
Yes, Your Honor.
Much has been made of, and rightfully so, your side, that he did not articulate what alternatives he had or wanted, correct?
Yes, Your Honor.
But I can maybe understand the merits of that, or the strength of that, I should say, as to the free exercise. But is that really dispositive as to establishment? Don't you have a responsibility to, whether Cutter applies or not, in engaging in establishment? Because you are, the theory is you are given license to do more as a government to establish something, because that's the only way you can do that for people who are wards of the state or the government, to have free exercise. So you're given a pass, if you will. Turner seems to suggest you say it better. But in doing that, don't you have to look at neutrality and lack of compulsion? So therefore, whether he puts forward those alternatives or not in the framework of establishment, that's that issue, isn't it? Because the question is, for example, you say, well, we couldn't find an imam. Well, maybe you only looked at the city limits. And maybe it requires you to go, but you can find many Christian churches within a stone throw of the institution. But wouldn't that, in terms of neutrality, require you to have a larger net to establish neutrality? Because, oh, well, you know what? I searched all just in the town limits and I couldn't find any. Oh, end of search. Wouldn't that be sort of facetious if you know that in terms of the demographics that you're in, that you have to go to the next major town?
Your Honor, I think, so what we have to do is what's reasonable. So you look at a jail in Stanton, Virginia, these are inmates in prison. There's just simply not going to be as many opportunities as there would be, say, in DC or even Richmond to get that type of service. So what we cannot do is coerce somebody to engage in a service that they don't want to engage in. We cannot coerce them to become part of, to watch the service. We didn't do that, okay? And I agree with you, we absolutely have to maintain neutrality, but our ultimate requirement is to provide reasonable accommodations for people to accomplish their religious exercise. And with what we've done in this case at this jail, we believe we've accomplished that goal. And absolutely, I agree with you. We must maintain neutrality, and I think we've done that here, Your Honor.
So I just want to make sure I understand your answer to the question, because I thought it was a good one. What is a reasonable response from the jail might well depend on the circumstances, right? And so if you, I'm not sure it's true here, but if you went out and sought donations from the Mennonites, my guess is they just came to you. But if you went out and sought them from the Mennonites, then you would have to do a reasonably comparable effort. And that might be broader or might be narrower, depending on what the religious group was. You're not disagreeing with that idea, that if you're doing a search for religious groups, that the nature of that search might depend on the nature of the religious group.
No, I don't disagree with that at all, Your Honor. Yeah, I think that
your point is here, you don't have to do a search at all, right? That's not the premise here, is that you're not required to go out and find religious speakers or provisions.
So long as what we're doing is providing, as long as we've already provided reasonable accommodations for inmates to accomplish their free exercise rights. Absolutely, Your Honor. And again, Your Honors, we ask that you would affirm the decision of the district court in granting summary judgment to the jail. Thank you.
All right, thank you, Mr. Harf. Ms., is that pronounced Camus? Camus? You'll tell us.
Thank you, Your Honors. Just a few brief points in response today. First, Firewalker Fields.
Counsel, can you, for me at least, because I'm a little challenged, can you pronounce your name so I won't mispronounce it if I ask a question?
Sure, it's Camo.
Camo.
Okay.
Yeah.
Thank you.
Thank you.
Okay, Camo.
Thank you. First, Firewalker Fields would have been content, and this shows in the record, with alternatives such as video or live stream services. You'll see in the joint appendix at pages 8, 9, 11, 13, 18, and 19 that Firewalker Fields requested that Joomla services are put in place at the facility. In no case does it mention in-person services. And while it might be true that he may have preferred an in-person service to an alternative video streaming of such services, the declaration of a preferred alternative does not automatically waive any other alternative to no services whatsoever.
Counsel, how do you deal with your opponent colleague's point that in the complaint itself and the relief that your client is seeking, he has articulated a particularized basis for how he wants to exercise his religion? And the bottom line is that that is not an option that's available, and he has not pled any alternative bases for being able to exercise his faith.
Right, Your Honor. Again, I emphasize that the declaration of one particular favorable way in which to practice these services does not waive any other potential alternatives. And in addition to that, as my colleague has said in our primary argument, if he had been granted discovery in this case, which he should have been, he would have we would have likely had those alternatives been made a little bit more clear. And in this case, that isn't even all that necessary. For instance, the facility already plays Mennonite services over the closed circuit TVs. We know for a fact that they have these readily available. And second, the inmate handbook, which is publicly available online, indicates that there are tablets available for inmate use.
If that's indeed the case, why didn't your client plead the same circumstances that the Mennonite services provided?
Your Honor, again, this schedule, our pro se litigant here was met with an aggressive mediation schedule, followed immediately by briefing. He's a maximum security inmate and did not have the necessary means to do so. And so under Pledger, he did what he was supposed to actually put the court on notice that he was supposed to be able to get that discovery.
The problem, so I mean, it's sort of the problem you've got is sort of a twofold one. I just want to make sure I understand the argument. One is the allegation, and that's what Judge Alston's talking about. But even if we get past that, the challenge you've got is that for in-person prayer services or for video, you got nobody that's offering to do them or provide them. And so you don't have a causation problem, right? So it's not the jail that's preventing him from having group services. It's the failure of someone to volunteer combined with his maximum security status. So to take that as an example, even if he alleged that as an alternative, it's not caused by the jail's limitation, but instead by his security status and the lack of a volunteer.
Your Honor, this policy is, it actually, we argue that it is not reasonably related to the penological interests at stake here. And, you know, in addition to that, sorry, one more time. I want to be able to answer your question appropriately.
So what I'm trying to understand is, so if I take away the pleading problem of what the relief is, but then I say, take for example, that he wants the video. I'll use that as an example. The problem we have is that the jail only allows donated videos, right? And there's no donated video here. And so that's a causation problem, even if that was part of his allegations, I guess. If to get through both of those hurdles is where I'm having trouble.
Yeah, no, thank you, Your Honor, for the clarification. I want to stress here that there are actually alternatives available to this very strict policy that's in place. So for instance, I understand that there's a concern with staff picking the services, for instance, and we understand that, but they at least could have presented the inmates with options here and let him choose. And then, you know, that's an alternative here that doesn't run afoul of the Establishment Clause as well.
So the idea is the warden picks the three that he likes the best, and that's not an establishment clause concern because the ultimate choice is made by the inmate.
Ultimately, Your Honor, our position is that in the context of a maximum security prison, the inmate is not going to be able to feasibly choose these without any aid from an outside source. And so in that context, then yes.
And I'll let you go, I'm sorry, but that's sort of the point, right? And that's why the warden says we need an outside source to do this. Like, I don't want to be involved in it because I don't want to endorse religion. You can't be involved with it for, I think, obvious reasons. So that's why we rely on an outside source to provide them. And the Mennonites do it for this religious group or some portion of that religious group. And if we got one, we'd have a different case if there was a video that was submitted for the Muslim faith and it wasn't played, right?
I mean, it's correct that while it would be nice if an Islamic, outside Islamic faith group donated a video here, because they are a minority religion, that's not as likely going to happen as for Christian services. And so, Your Honor, all we're doing here is presenting alternatives that are feasible under the circumstances.
Thank you very much. Appreciate you.
Yeah. And if there's no other questions.
I just want to be very clear.
Yeah, absolutely.
When you said that alternatives were presented, that's in the context of the pellet process. When were they presented?
Apologies. In the joint appendix?
Yeah, the site.
Yeah. So on page...
And who were they given to? Because much has been said that he never suggested anything other than a communal prayer. But you say that's not the case, right?
Right. And in all of his complaints, for instance, throughout the joint appendix, again, these are on pages. I can turn to the pages and read the language.
No. What I'm saying, you say he did it before litigation or during litigation?
I believe before litigation.
Before litigation.
Yeah.
Right. Okay.
Yeah.
All right. Thank you so much. Counsel, thank you all. And Professor, thank you so much. Mr. Martinez and Ms. Kamal, thank you so much. You've acquitted yourself well as Cavaliers. Thank you so much. And we appreciate your helping the court on these cases, your court assigned. And as Judge Austin said, you're far cry ahead of me in terms of doing law school days and being an appellate Fourth Circuit Court. That's impressive, and you have performed and done very well. Mr. Hoff, of course, your able representation as well as the regional jail. Thank you so much for your being here. We can't come down and shake your hands, but know that we appreciate you very much, and we wish you well, be safe, and take care. Thank you so much. All right. Unless you want to break, you good?
Okay. Good. Ladder's holding up pretty good.
All right, Madam. Mr. Duncan, when you're ready.
Thank you, Your Honor. Good afternoon. May it please the court. Dana Duncan on behalf of Vance Calkins. This matter comes before the court on a claim for disability benefits. Mr. Calkins suffered a hernia while in the United States Coast Guard. That hernia occurred later, is resulted from having nerve damage and nerve pain advancing into the abdomen and groin area as a result of this. He received a 100% disability rating from the Veterans Administration with a finding of 100% disabled for employment purposes. The date last insured in this case is December 31, 2014. Therefore, if the denial of benefits in this case would prevent him from obtaining or securing disability insurance benefits unless he reestablished insured status.
Mr. Duncan, let me ask you this question because it helped me kind of get to where I think the case goes. What is the standard of review for this court?
The standard of review is substantial evidence review. The problem.
Let me follow up on that.
Yep.
Suppose hypothetically, and we speak in hypotheticals a lot of times because it helps us work through the analytical framework. Suppose this had been a case that was one that would go to a jury. Right. And suppose that during the course of that case, you had two experts, and that's what we see all the time in cases that go to trial. It's a battle of the experts, which one the fact finder believes. And the fact finder in that case had found against you. Obviously, the standard of review would be probably deferral to the determination.
Correct.
Seems like the standard is even more difficult for you here because what we again have is a battle of the experts. One expert supports your client's point of view, the other expert does not. And with our limited review authority, why isn't that determinative of how the case should be resolved?
Because of two reasons, Your Honor.
Yes.
First, the doctors in this case that provided opinions were treating source. The treating source rule still applied at the time this case went forward, which this court has held as recently as last year in another case that was actually briefed about this and argued about the same time, but the decision was not made until early last year, Arrakis, which indicates that the treating source statement is given authority and can only be overcome if there's contrary or substantial contrary evidence. In this case, the substantial contrary evidence that the ALJ points to is the non-examining medical opinions. We have a state agency doctor, one of whom was a general practitioner, and the other, drawing a blank off the top, but neither had any real significant experience in dealing with neurology or orthopedics. And then on the other side, she indicated 2 points, or the judge did in 2 points. One was his wide-ranging daily activities and his lack of treatment. Social Security rules, their own rulings, their requirements state what the judge is supposed to do. If they can't even follow the rules that they establish, then there's a problem. This court should remand. In this particular case, the judge went and said, treating, no failure to treat. There are 2 specific Social Security rulings that indicate a judge must make inquiry and evaluate why the treatment was not followed. For example, in SSR 16-3P, it specifically indicates that if the claimant has significant side effects regarding medications, he does not necessarily have to take those medications. In this particular case, Mr. Calkins had significant medical symptoms and side effects from his antidepressants. He also indicated that at one point in time, they made his condition worse.
But didn't he also said something to the effect as he didn't take the medication because he didn't like pills?
Correct. Now, and I understand this court has not, but sister courts have held that that's part of the issue of mental illness, which is when you have mental illness, it's not something necessarily you like to admit and you try to avoid it. It is unfortunate, but that is a reality of the situation. And I think to some extent that was what was going on here. When his condition got to the point where he was suicidal, he started taking the pills again for a while and seemed to stabilize, but still the problem is there was never any real inquiry, and there's nothing in the decision that outlines any of this. The second thing is the daily activities. This court has repeatedly said in precedent that the ALJ has to evaluate those daily activities to see whether or not they're consistent with the ability to work. And if you are not, or you can only hold that against them if they do not, or if they are unrelated to work. For example,
but this record suggests that he was able to vacation in Hawaii. He was able to take care of his sons. He was able to do, I guess a good way of explaining or identifying is that things that he enjoyed doing, he liked to do, but other things he didn't so much like to do.
Well, as far as taking care of his children, I'll just quote Judge Posner from the Seventh Circuit, who said, what option did he have? Is he supposed to put them into social services? Just because you suffer from a disability does not mean that you have to stop living. It is not, as the Ninth Circuit said, place you in a condition where you live your life sitting in front of a TV, unable to function. The question is whether he can or cannot perform work on a sustained daily ability. If he only is limited, say he can work for 6 hours a day, he's still disabled under the law, because you have to be able to work 40 hours a week, 8 hours a day. That's the definition of sustained work activity. And in this particular case, that never happened. Moreover, so that's part of it. And then the other part of it is it always comes down to substantial evidence review somehow or another has become some sort of catch-all that means a completely differential view of anything and everything and all aspects of this. And it's not. It's all about the level of articulation. That's what the Supreme Court established. That's the way the laws were written back in the 30s when this was established and created. And in this particular case, we have wide gaps of stuff that were never addressed, never discussed, and which do not support the conclusions. So I would point out that the problem also comes in here, that the judge just in looking at the VA decision, we're not talking necessarily that the ALJ was required to adopt their findings or their conclusions, but the judge cannot just simply go, I've considered it, and ignore their detailed assessments. I mean, they went through and did a compensation or a compensation and pension examination with some very great detail and went on.
Can you point me in the record to the I want to understand the record. So I'm at JA 202, which I understand is the individual unemployability decision by the VA.
Yes.
And when I look at it, there are lots of words, but I only see the analysis is the evidence shows that you're unable to be sustainably employed. I mean, that's the analysis, right? I mean, there are lots of words here, but that's the extent of the analysis, right? And so, which is fine, but you say they did a detailed analysis. And so in the VA, what am I missing? Am I not looking at the right document?
I'll refer you to Dr. Morton's compensation pension examination. Our 407 was done on April 27th of 2012. which was referenced and noted, and which was ultimately incorporated into that decision itself.
But it's not incorporated into the analysis, right? So that's the rub I'm having is when I read the analysis of the VA, which it's totally entitled to, right? It doesn't have to do anything more than it wants to.
Right.
But it just said, it gives the conclusion, right? I mean, it states a lot of standards, right? And goes through and it talks about the evidence that was presented. But when it gets to the analysis, it only gives the bottom line.
Yes, unfortunately, I did not create the record.
But you said they gave detailed analysis, right? And so what I'm looking at here doesn't seem so detailed.
What I'm referring to as detailed is the compensation pension examinations and other things in the record which were used when they wrote that decision. In other words, the foundation of that is in the record and has to be evaluated, and it was not.
Do our cases say that the record of the VA decision is entitled to deference, or that the VA's decision is entitled to deference? It's the decision of the VA, not the record in the VA case. It's the decision. We're deferring to that decision maker.
Yes, but in order to defer to the decision, you have to have some idea of what the basis is, which means you evaluate medical opinions that made up that. Unfortunately, there were probably 5 to 8 pages that did a detailed assessment that were not in the record, because that is just the decision. The actual support for the decision was not in there. So I don't know what happened to that, but you would go to and look at Dr. Morton's evaluation. So if there are no other questions, I guess I'll reserve any time I have left for rebuttal.
Thank you, Mr. Duncan. Ms. McWilliams.
Thank you, Your Honor. Good afternoon, and may it please the court. Lenita McWilliams on the behalf of the Acting Commissioner of Social Security. The claimant was in his 30s at the time of the ALJ's decision, and at that time, the ALJ found that his hernia repair, his nerve resection, and his related complications were severe. To account for the claimant's pain, he restricted him to sedentary work, which is the lowest level of exertional work that a person can perform in the competitive workforce. The ALJ only found that the claimant was not disabled based on his ability to perform unskilled sedentary work as directed by Social Security's grid rules. The claimant's core disagreement with the ALJ's decision is centered on the Department of Veteran Affairs disability ratings in the record. And the VA based this rating primarily on the claimant's mental impairments. Although the VA explained at page 1050 of the record that the claimant's rating was not permanent due to the likelihood that his mental symptoms would improve. So I will start by briefly addressing how the ALJ considered the VA rating. And then afterwards, I will discuss the ALJ's evidentiary analysis, which supported his findings. At page 851 of the record, the ALJ summarized 2 persuasive, specific, and valid reasons for giving the VA's rating less weight after carefully reviewing the evidence. One, he stated that the clinical evidence was a reason, and this clinical evidence included records that the VA did not have before it when it was making its most recent decision in October 2013. And second, the ALJ stated that he looked at the claimant's array of daily activities. The ALJ offered supporting details at his step 2 analysis, which begins at page 838 of the record, and his RFC assessment, which begins at page 845 of the record. As this court stated in McCartney v. Apfel, the ALJ only needs to review the medical evidence once in his decision. And as this court stated in Keene versus Berryhill, the court considers the ALJ's decision as a whole. It is the clinical evidence and daily activities that the ALJ describes in this detailed analysis at pages 838 through 851 of the record that informs his rationale in making his decision, which I will.
That's basically it, isn't it? And when it comes to mental impairment, it's only juxtaposition against these daily activities, because there's nothing on the other side in terms of the commission that's contrary in terms of psychological evidence, is there?
I'm sorry, Your Honor.
Is there any psychological expertise that says he does not have these problems? on that side? At IME, for example, from the commission, don't you rely solely upon saying, because he can do these things, then I'll give little weight to this psychological evidence, but you don't have on the other side psychological evidence saying that that's wrong. You're taking that, and that correct? I just want to make it the framework. Isn't that your argument? Because he can do these things, you can tick them off. Children, go to Spain, and even contemplate going to Mexico and doing things like that, washing clothes and shopping, right? That laundry list of activities is what you're saying that militates against psychological evidence from the VA, right?
Yes, and that's
it, correct?
That's not all, Your Honor.
Well, tell me what else you have on your side that these psychological findings, clinical, diagnostic, or prognostic, or otherwise, that's on the other side of that.
Okay, and so yes, the ALJ, he considered the activities of daily livings as a portion, and he considered it in context with the full clinical picture. At 838 through 845 of the record, the ALJ gave over 6 pages of detailed analysis to explain his findings. And in that portion,
I think you must have misunderstood my question. What expertise do you have that psychological evidence from an expert that says they're experts in psychology is wrong?
Well, so the ALJ pointed to reports from Dr. Morton, who is a consultative examiner that the agency sent the claimant to. And Dr. Morton said that the claimant appeared to cope with irritability well. He could cooperate with authority figures. And Dr. Morton also said that the claimant clearly had the ability to understand, retain, and follow instructions. And so from this examination, which was based on a one-time review of the claimant, and as well as Dr. Morton's review of the records that he had made available, the ALJ considered those findings from the record.
But didn't Dr. Morton say he had a mental impairment too?
Dr. Morton did say that the claimant had a mental impairment, and the ALJ also found—
Everybody did who had the expertise. Only the ALJ. Everyone who had expertise said yes, but the ALJ, you said otherwise.
No, the ALJ did not deny that the claimant had a mental impairment. The ALJ just found that the claimant's mental impairment was not severe enough to affect his ability to perform unskilled work activity.
But the problem is, though, work environment and home environment are totally different. There are people, for example, who have documented DSM-3 diagnoses, schizophrenia, whatever. They can operate at high levels. But if you put them in a work environment where it has to be structured and attention, and somebody said, did you get that right? It could be disastrous for them. So you're saying because that person who, for example, has a DSM-3 finding can have comfort with their children, go shopping and do those things and operate that means that, oh, because you can do that, we could put you in a working environment and you clearly— Do you have anybody, any expert that says that on your side?
No, and that's not what the ALJ is relying on. He's not just simply relying on the claimant's ability to perform these activities. He's looking at the claimant's activities in the context of the entire clinical picture. So the ALJ, he examined the claimant's treatment history. And for example, he noted—
He looked at it. He looked at it.
Yes, he looked at it. And he noted at pages 841 and 843 of the record that he first treated with Dr. Connolly in January 2013, and that she had only treated him 7 times within a 14-month period. And while the claimant was treating with Dr. Connolly, he reported that he was doing better. He was no longer depressed and just sad. And she prescribed him a low-dose antidepressant to deal with these residual symptoms that he was reporting, but he refused to take them. And at page 842 of the record, the ALJ explained that the claimant continued to be non-compliant with medication because he did not believe in taking pills, although he found the medication helpful. And he would start and stop his medication at will when he thought it was necessary.
You realize that denial of medication is a big problem with many people who have psychological problems?
Yes, and that is very well true, Your Honor. But in this case—
Does that mean that they don't have them? For example, a person who's bipolar, for example, it is important that you keep your chemistry in your blood very well regulated. one of the biggest problems is getting them to self-medicate properly. But that doesn't mean they're not ill.
That's correct. And
But
I don't think
that's a part of the symptoms of their illness. It's like telling somebody who's manic depressive, just cheer up. Well, if they could cheer up, they wouldn't be manic depressive. So part of the reason why they don't take their medicine is the same reason that they're ill. It's circular. It's not linear. I mean, because that whole problem, the courts come in, we write opinions, and we ignore science all the time. I mean, we write these opinions. You know, the LH, it's circular. That's the whole problem. People who are addicted to all kinds of things in terms of drugs, well, why don't you, if you just could stay away from it? That's one of the problems. They can't. And that's why they need help. But if you're saying that this is because they can do this, that's what I want to make sure. Because they can do these activities, because they did not have a good regimen of taking their drugs, because the psychologist didn't overtreat and tried to get him to have coping skills rather than having multiple visitations, because that's what you're saying. Oh, you only saw him 7 times. That may be good medicine because that helps get coping skills, because at the end of the day, you have to live with yourself and be able to discipline your medication and cope. But you're taking all of these things against them without any science or anything on the other side to your position.
Well, the one thing, to Your Honor's point, the one thing I want to point out is that the ALJ did not disregard the claimant's treatment in that respect. He actually found that despite this sporadic compliance, which is the words that he used, that the claimant still demonstrated overall improvement in his mental health, as shown by his stable mental status examination findings. In the record, there were occasions where he had mood difficulties and his effect was restricted. But there are also many other status examination findings that shows that his mood was dysphoric and he was completely stable. So the ALJ is taking on a balancing act when considering both the positive and negative findings. And based off of taking all of these factors together, the claimant's ability to go on trips, to extensively research his impairments, to just take control over his life in a way, despite how he's feeling, and also his desire just to not treat his mental impairments with medication that he agreed does help. The ALJ drew the reasonable inference that his symptoms must not be as severe, which is appropriate based on the facts in this record, although it always might not always be the case.
Counsel, do you agree or disagree that this case is substantially resolved by the standard review of this court?
I would agree with that, Your Honor.
And what if we had a situation, though, with taking into consideration the appropriate standard review, if we had an incomplete record, if we make the determination, not that the district court was wrong or the ALJ was wrong, but rather we have an incomplete record to make that determination, would your answer be different?
Depending on the facts of the case, my answer very well may be different. For example, if the claimant produced something that was not introduced into the record that would materially alter the ALJ's decision, then in that case, yes, it could change the outcome. But we don't have that here at this point in time.
Can I ask a record question?
Yes.
Sorry, and you've been great with Jay sites. I've been scribbling them down. I certainly appreciate them. Is there anything in the record that suggests that the nature of the claimant's mental illness inhibited his ability to make a voluntary choice to take medications or not? I mean, I certainly take the Chief's point. In some instances, that's true. But is there anything in this record that suggests the nature of his particular mental illness? I mean, did the doctor find that he was, unable to make a voluntary choice about medications or not?
No, there's nothing in the record to that effect, Your Honor. And actually, the ALJ pointed to one of the VA doctors. I believe it was a Dr. Aaron, and his reference can be found on page 1093. And surprisingly, this VA doctor who was looking at his mental impairments said that his mental impairments did not deem him unemployable, even though the VA found otherwise. And so it's this, when the ALJ is faced with all this conflicting evidence, it's his job to resolve those conflicts in evidence. And that's what the ALJ did here. And his decision outlines his rationale. It outlines the various pieces of evidence that he's he's reviewing and that he's taken into account, and his evaluation is afforded significant deference.
Do you know what, of course, you know what his disorder is, don't you?
Yes, Your Honor.
What is it?
He has depressive disorder. It was characterized many ways in the record. Some clinicians said adjustment disorder, but depressive disorder.
And when you have depressive disorder, what, in terms of spectrum, what spectrum in terms of human thought and everything that covers? Because Judge Richardson asked you a very important question. He says, is there anything in the record that would suggest anything about his disorder that would impact your ability to take medicine? When you have depressive disorder, doesn't that cover the whole spectrum of your thinking?
It primarily deals with your mood and your motivation. But
like that, some days you can't get out of the bed.
That's correct.
That's that would be your whole day, wouldn't it?
That's correct, Your Honor. But depending on the severity, the degree of depression the claimant has, and in this case, the ALJ found that the claimant's depression was not on the extremely severe spectrum where he would be able to get out of bed. Rather, it was on the other side of the spectrum where, yes, he has some difficulties. He's struggling with some things and coping, trying to get coping skills to manage these different areas of his life. But the record does not show that his depression is so debilitating to the point where he cannot manage his treatment, he cannot comply with treatment, and he cannot get out of bed, or he cannot perform unskilled sedentary work. And I think that's the point that the ALJ is making.
You know, we're dealing with people, veterans coming from the wars, Gulf wars, with post-traumatic stress disorders. They look healthy fit as a drum, fit as a fiddle, if you will, but incredible, debilitating problems. And we read like that, depressive disorder. What does that mean? Well, but look, you look healthy. I see you taking your kids to the theater. You go to a park. But the trauma they dealt with in terms of in the Gulf Wars and what they saw in those things impact, it's incredible impact. And just to say, well, you know, you look well, you're fine. You just have this depressive disorder. That doesn't impact your ability to work. And it'll be different if this was a case where you had a malingering scale, which you could have done. There's no evidence in this record that he's a malingerer, is there? Is there?
Not to my knowledge.
Right. And there is a malingering scale that you could have put him through, couldn't you?
Yes, Your Honor.
That's right. But then you come and say, well, no, it's just depression. Depression covers everything.
But if I'm out of time, may I?
You know, but I'm the chief, so I'm asking you the question. You're always in good stead.
Okay, thank you, Your Honor. The ALJ was required to evaluate the evidence that he had before him. And based on this complete record, he was able to make a determination. And he decided that based off of the clinical picture that was before him, showing the claimant's improvement with treatment and without treatment, the claimant's stability, that his mental impairment was not severe. He did not deny that the claimant experienced some symptoms or some difficulties. He just said that under Social Security's rules, that it did not prevent him from performing unskilled work. Thank you, Your Honor. I will rest on the brief.
Thank you, Ms. McWilliams. Mr. Duncan, you have some time reserved.
All right, thank you. I just want to make one point. He was limited to sedentary work. The fact that there were absolutely no restrictions placed on him for mental impairment was significant, because almost all sedentary work involves working with people. And the VA decision and the deference that's owed to that, the VA on page JA 1049 and 1050 noted that he had near continuous panic affecting his ability to function independently, difficulty adapting to stressful situations, inability to establish and maintain effective relationships.
Can I just want to make sure I understand what the record we're looking at. I was trying to pull up 1049 to see what it is. Is that the VA examiner's decision, or is that just evidence that was before the VA decision?
The actual VA decision says the 2013 decision specifically noted and stated, we have assessed a 70% evaluation for your depressive disorder based upon, and then outlines all of these. And we're talking in here.
And that's at 1049. So when you're quoting there, you're quoting from the 2013
decision. Correct. So we have an individual who has difficulty working with others, and now we're going to put him in a sedentary position. And at the same time, while the standard of review is the substantial evidence standard review, the law is that there has to be articulation. The judge never discusses in the entire decision that there should be a consideration of controlling weight for Dr. Conley or Dr. Kelly. Both were, 7 times. So she only treated him 7 times. Dr. Kelly or Dr. Conley did. That's a lot, really, for a medical opinion. I mean, the state agency doctors made an opinion. They found mental impairments. They never examined him, but we have no problem relying on that. In this particular case, there is so much in this as far as the 2 medical opinions by themselves, just focusing on those 2 medical opinions and the fact that all of the other medical opinions are consistent with each other. The state agency found mental impairments and said there was limitations. The Dr. Morton said it.
Can I go back? Because I just want to make sure I understand the VA. So the 2013, which was not the unemployability decision, but is instead just focus on the increase from 50 to 70%.
Yes.
Includes the conclusion that the evidence does not show total occupational impairment. So in other words, they conclude there that based on the mental side, he is able to work, right? I mean, that's the conclusion. Now, that's inconsistent with the 2011 decision, but what they say is that it's not disabling because you don't show total occupational impairment.
The standard itself is different for the VA than it is for Social Security. Ultimately, the fact that they made these specific mental impairments together with what the ALJ found to be sedentary. I've been in the...
Right, but you're asking us to, you're cherry, I just want to make sure I'm understanding. It's just cherry picking. You're saying, look at the things they said, look at those, but ignore the conclusion from the VA that he does not show total occupational impairment. So in other words, he's employable after they describe all these things. So if I'm reading that fairly, what I say is the VA has found you have these impairments, yes, but they are not of such that it would prevent you from working.
And that's correct. The standard, though, for determining what is and is not unemployability is a different standard than Social Security, because in this
I get that, and that's an important point. They are different standards,
sure,
right? And we might think about that and whether you have to rely on the VA's decision. But my point is the VA is finding the impairments you want us to talk about and then finding that he does not have total occupational impairment, right? Whatever their standard is, that they're making that decision. And I guess what I'm saying is, shouldn't we rely on that just as much as we rely on the 2011 ALJ or 2011 VA decision?
I understand your point, but what you have to really focus on is the specific findings that I outlined, because the VA did not limit him to sedentary work. The VA gave him a rating on his physical impairment. The fact that he is sedentary and the residual functional capacity with all of these additional mental impairments would come in. If you would put limitations on his ability to function in a work setting with any one of these, you could pick 3 out of that whole list from JA 1049 and 1050. And I will virtually guarantee a vocational expert will say there is no work at the sedentary occupational
level. The problem I've got, and I'll give you one chance to sort of help me get my head around this, is I understand that's your opinion and you can guarantee what a vocational expert will say, and that's great, right? But that's not helpful to me,
correct?
Right? Because, I've got evidence on both sides. I've got some VA examiner that says, I've looked at his mental state and that doesn't render him different standard, but same basic idea, totally occupationally impaired, right? And you got other people going the other way, right? And so the challenge that I've got, and what it sort of goes back to Judge Alston's point, is there are a lot of these things. And yes, there are people on both sides of Dr. Aaron's one way, Morton's the other way. The VA examiner in 2011 is in your favor and 13 sort of is against you. And the ALJ makes a sort of judgment about that. And I'm sort of stuck with seeing how I can reevaluate that.
The fact simply is that he gave absolutely no limitations for mental impairments, despite the evidence here. And he did it only on his own opinion. The state agency doctors found mental impairments. Dr. Morton found mental impairments. Dr. Connolly found mental impairments. The only person who did not feel that his mental impairments were sufficient to cause some level of limitation was the ALJ. And if that's not the definition of playing doctor, I don't know what is, because he doesn't even have anything other than, he doesn't even point to specific medical findings necessarily. He points to daily activities, and he points to his lack of treatment. And the brief outlined how both fail, both of my briefs did. And not to mention the fact is that we also have Dr. Kelly's opinion, which we have the same problem with. He said he was going to need to have unscheduled breaks. He was going to be absent more than 3 days a month. All of those would also support a finding of disability. And the judge doesn't really go through. He just again says, I don't find them supported by the record because of his daily activities and his lack of treatment. That's all we have.
And if we could go circular back to the very first question that I asked, and I don't think it's necessarily dispositive, but I like the question. I thought it was a pretty good one, is that as long as we can look at this record and evaluate from the point of view that we have to as judges sitting on an appellate court, and whether I disagree with what the ALJ found, and I will tell you this, it's a tough record as far as disagreeing with the ALJ. The ALJ's not really what I think I would have come up with if I had been sitting as the ALJ in that court or in that case. But in this case, because the standard is more than a mere scintilla of evidence, which takes us back as long as there's something in the record to support the finding of the ALJ and the district court, we're stuck.
No, Your Honor. And the reason is because it's still an articulation standard. The judge has to put down in writing within the four corners the basis of his decision, and it has to be substantial and clear. And something that, the Seventh Circuit uses, build a logical bridge as their catch-all phrase.
Sounds like Judge Posner.
Yes, Judge Posner. And Judge Duncan in this court wrote the case where Patterson, where it says they have to show their work. That's the problem, is that the work is not being shown sufficiently in this case. If we didn't hold them to that standard of articulation, all the ALJ would have to do is go case denied, see attached, and print out the record.
I think that counsel, as Judge Richardson always does, it is very, very wonderful acumen in terms of honing in. It's a good point, but I think it's right there. The answer is that what the VA is saying is, no, there is something that he can do, but that is not enough to justify the RC after they came up with, because you still got to run the gauntlet, as you said, with all of the mental impairments that he has to find the job. So yes, there may be a job, but you can't do it by saying, okay, you can be a ticket, you can be a cashier, you can do that because they're a bunch. But when you put that alongside the dysfunctional in terms of dealing with people, there's still a problem. You have to find a job where he doesn't have to deal with people and run that gauntlet. And yes, there is something out there, but you can't do it by ignoring, by saying, oh, he can do something now. Let's give him that normal. I see it all the time. Out there's a ticket you can take. There's a lot of ticket takers. I don't know what they're taking tickets for, but anyway, they take tickets and they're cashiers and they're working and stuff like that. But all of them deal with people. So you can't ignore that line and say, oh, you can do something. Yeah, then there's nothing on the other side that said he could do something if you consider these impairments. That's why. So we don't have to defer to that, even with a lower burden of substantial evidence, in my view.
The numbers have to be a substantial number of jobs in the national economy.
Exactly.
So,
exactly.
If there are no other questions, I guess I've spoken enough.
All right. Mr. Duncan and Ms. McWilliams, thank you so much for your arguments. You have helped us very well in all these difficult cases, and we appreciate your arguments. We can't come down and shake your hands, but know that nonetheless that we appreciate it so much your being here, and we wish you well and be safe. And thank you so much. And with that, I'll ask the clerk of the court to adjourn this session, the morning session of the court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.